justice, where are you? Michael and Linda are here.
Love you, Linda.
The world is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and down, will I lead the way? Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
In the shadows, truth takes form. Every clue a raging storm. A puzzle piece is left to find. Justice served, no wasted time. Follow the trail, step by step. No secrets kept, no stone unwept. Facts laid bare, the proof aligns. Beyond the doubt, justice shines. Whispers echo in the night. A legal war, a righteous fight. Advocates with steel resolve. The tangled threads they will dissolve. Through the chaos voices plead. The gavel strikes to meet the need. Strengthened hands to bear the weight. Each decision carves our fate. Follow the trail, step by step. No secrets kept, no stone unwept. Facts laid bare, the proof aligns. Beyond the doubt, justice shines. Linda's keen, a mind so vast, breaking down the shadows cast. Michael's sharp, a guiding hand. On firm ground, the fearless stand.
No secrets kept, no stone unwet.
Facts laid bare, the proof aligns. Beyond the doubt, justice shines.
In the silent hall, Linda unlocks the mystery's thrall. Michael charts truth with steady hand. Through shadows deep they make their stand. Dig through the lies the world conceals. Evidence whispers what the dark reveals. Mascots to be and domino play their role, guiding us closer to justice whole. Justice serve the truth untamed. Every story we've unframed, chasing facts as they unwind. Through the chaos, clarity shines. Blackened files and forgotten tales echo down corridors no wind wails. Together they conquer every climb, steering through the storms of crime. Every lead, another thread to pull, through blurred lines where the danger's full. Linda sharp as a blade of law, Michael's insights flawless and raw. Justice serve the truth untamed. Every story we've unframed, chasing facts as they unwind. Through the chaos, clarity shines. Justice, where are you? Michael and Linda are here. Where in the world is justice? Will we ever find justice? Will we know justice when we see it? To be and down will I lead the way, hoping justice will win the day. Listener clues, finding justice where we can. Join us in the hunt. The road is dark, the truth is hidden, but we won't rest. We'll keep on risking. Justice is a fight we can't ignore. We'll keep searching till we score. Michael and Linda, the search goes on. The hour is late, but we're still strong. Where is justice? What does it mean? A final answer, a truth unseen. The streets are cold, the night is wide, but we
the trials on display. Linda and Michael guide the way. Mascots hopping, dominoes fall. To be spinning, let's answer the call. Justice Serve TV, get on your feet. The courts in recess, feel the beat. Legal fire with rhythm alive. Dance it out with justice jive. From the bench to the floor we groove. Commentary sharp and smooth. In the courtroom or on the stream, we break it down while chasing the dream. Oh, Justice Serve TV, get on your feet. The courts in recess, feel the beat. Let the mascot spark the lights. Dance through the trial, ignite your nights. Break it now, no time for objections. Spin it now in all directions. Linda snaps a fact, Michael's on the move. With justice jive, it's time to groove. Witness the rhythm, vibe in session. Trial watching turn to a confection. Mascots jive and jurors sway. Thanks for being here today. Break it now, no time for objections. Spin it now in all directions. Linda snaps a fact, Michael's on the move. With justice jive, it's time to groove. Witness the rhythm, vibe in session. Trial watching turn to a confession. Mascots jive and jurors sway. Thanks for being here today.
This court is now in session. You may be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, we call the question about the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. The Commonwealth is represented by Assistant District Attorney Dennis Sprague and Assistant District Attorney Shane Bellamy.
Well, good morning, everyone. Good morning, counsel.
Good morning.
Morning, Ms. Clancy. Before we get going, we may have a little bit of a delay actually starting at this point through no fault really of anyone. So I just kind of wanted to come out, so maybe we go sidebar, kind of talk about what the schedule is, and just so everybody's aware that we're trying to get this moving. So, counsel? All right, so at this point, what we're going to do is we're going to be in recess, and we'll come back as soon as we can in regards to this. We'll resume the trial at that time. Okay, thank you.
Board, all rise. Court is back in session. You may be seated.
First, the record Lindsay Clancy, Commonwealth versus Lindsay Clancy. All parties are present, excluding the jury.
All right. Counsel, we ready for the jury?
Yes.
All right.
Court, all rise, please.
Hey, all persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court now sitting in Plymouth, within for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Yes, please.
Your Honor, before the court today, we have a continuation of the jury trial in the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington, and the Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Shannon Buckingham.
All right. Thank you, Madam Clerk. Good morning, members of the jury. Nice to see all of you. I appreciate you being here. So what I'm going to do is we're going to go over the questions that you know are coming, and then what we'll do is we'll get right back into the case. So the first question is: any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be fair and impartial? Next question: is there any other serious matter or concern bearing on your service as a juror in this case that anybody needs to bring to my attention? Again, thank you so much for following those instructions. And so what we're going to do now is we broke yesterday. There was a witness on the stand who was testifying on behalf of the defense. We're going to return to that witness at this point. And so if the witness could retake the stand at this time. Yeah. Morning.
Good morning. This one is the testimony made in Chief of the Court and the jury that the opening between the Commonwealth and the defense shall be
I do.
You may not say.
Good morning, Doc.
Good morning, Your Honor.
All right, Attorney Reddington.
Thank you, Judge. Sir, I'm going to try to just redirect towards the interview that you had of Lindsay regarding her journey. On November 29th of 2022, do you recall which healthcare provider she visited?
I believe that Ms. Clancy saw Ms. Gelada for treatment.
That'd be nurse practitioner Gelada?
Yes.
Do you know what she complained on November 29th that her symptoms were?
She was having issues with unstable mood, depression, and psychotic symptoms of disassociation.
Did she also, on that date, November 29th of 22, complain that she had what is referred to as a flattened effect?
Yes, and that was also paired with derealization.
And what does that mean?
That an individual experiencing derealization doesn't feel things are real when they look around. They don't think that what they're seeing is in the reality that they're in.
Now, at this time, towards the end of November into early December of 22, she was living in Duxbury. Is that correct?
That's correct.
And she's living with her husband and her three young children, correct?
Yes.
And was the husband working?
Yes.
Where was he working?
Pardon me, Attorney Reddington?
Where was he working?
He was working for Microsoft, but in a home office that was in the basement of the house.
And she's obviously taking care of Callan the infant and Dawson and, Cora.
Yes.
And the kids were in school a couple of days a week in the preschool, the Little Sprouts or something like that, right?
Yes.
So did she improve at that point, sir, or did she end up going to South Shore Perinatal Clinic on December 2nd?
She did not improve. She was getting worse. She did go to the South Shore Perinatal Clinic.
And would that be on December 2nd?
December 2nd, yes.
And what was the reason, what were her complaints that brought her to South Shore Perinatal Clinic on December 2nd?
She felt that her brain was damaged. She felt that she should kill herself. And she's never going to get any better.
Did she also express fear that people could hear her thoughts and that anything adverse would happen in her life regarding being a mother and having children?
Yes, that's called thought broadcasting.
And what was her concern about the children?
Her concern was that when people could hear her thoughts, her children would be removed from her care.
Now, and keep your voice up, please.
Yes.
Did she indicate, and I quote, that she had bad and intrusive thoughts, and she didn't even feel that they were like mine, telling me I should kill myself, my brain is damaged, you're never going to get better?
Yes.
And did that type of intrusive thought or persecutory thought continue for a period of time?
Yes. So it got
Did it
worse.
get so bad that she ended up doing something?
Yes, that's correct.
What did she do?
She called the suicide hotline.
And do you know when that was, sir?
That was December 4th, 2022.
Did she receive any help from the suicide hotline?
She did not.
Why is that?
They told her she did not meet the standard of care because she
And-
did not have a plan.
Did she call the suicide hotline again, if you're aware?
Yes, she did.
Do you know when that was? Was that in December?
Yes, I believe that was perhaps the following week around the 15th, but I'm not positive about
Did
that.
she receive help on the second call that she called the suicide hotline?
No, she did not.
Can you tell us at this point now, we're talking about in December, let's say towards December 15th or thereabouts, what were her symptoms at that time regarding any complaints or observations that she had about paranoia or things of that nature?
Yes. She was having paranoid symptoms of psychoses, and she was getting more depressed.
Did she make any comments about DCF or the police at that point?
Yes.
Now, to your knowledge, did she ever have any involvement in her entire life with the police?
Never.
And did she express that she was in fear or concerned about DCF and or the police in the middle of December 22?
Very much so.
What did she say?
She was worried that her children would be removed from her and that she would never see them again.
Now, at this point, what medication was she on? First paragraph, page 9.
She started to take, at that point, Seroquel, Remeron, and Klonopin.
Did she make any complaints at that point about the effect, if any, of
Yeah.
the medications?
Yes.
What did she say?
She said she felt like a zombie.
Did she present with any particular medical observation that you refer to?
I'm not sure I understand your question.
Well, paragraph 1 on page 9, you indicate she presented with anhedonia.
Yeah.
What does that mean?
Anhedonia is a word that means without pleasure. When someone has anhedonia, they cannot enjoy life. They don't laugh. They have no pleasure.
Continuing on into December, what was her status of her condition of depression and symptoms of paranoia and intrusive thoughts, et cetera, that we've talked about?
It continued unabated.
On December 15th of 22, right before the holidays, did she go somewhere?
Yes, she did.
Where'd she go?
She went to the clinic in Rhode Island, Parents and Women's Clinic, partial day hospitalization program.
And she didn't get any help there either, right?
That's correct.
Did she go at some point around that same time frame to Mass General Hospital?
Yes, she did.
Now, you knew that she worked at Mass General Hospital for 9 years, right?
That's correct, in labor and delivery.
She wasn't there visiting friends, right?
That's correct.
Why was she there?
She was there in the emergency room to seek help.
Did she get help on that day?
She did not.
So after going to the MGH ER at some point in December 30th, what did she do?
She went back to the emergency room at Mass General.
Now, for example, on December 15th, did Pat Clancy, her husband, get involved with her medical treatment?
Yes.
And do the medical records indicate that he did something with her?
Yes, he brought her to the partial hospitalization program in Rhode Island.
Did he also bring her to the Mass General Hospital ER?
Yes, he did.
Did he also bring her to see the doctor or the nurse practitioner, Gelater, and complain about the medication?
Yes.
So December 30th or 31st of 2022, she was admitted voluntarily to McLean, right?
That's correct, yes.
How long was she there for?
She was there till the 5th. She was discharged January 5th, 2023.
Was that a voluntary discharge? They cleared her as well to be discharged?
Yes.
That was not what is referred to as AMA, or against medical advice, right?
Yes.
Yes, what?
Yes, it's not AMA. It's not against medical advice. She was following hospital guidelines. She was discharged accordingly.
And she wanted to go to her daughter's some function?
She wanted to go to her daughter Cora's birthday party, which was held on the 7th of January.
Now, at this point, what was her status? Was she weaned off of medication, or on her way to being weaned off of medication when she got out of McLean?
I believe so, yes. She was being tapered down on her medication.
And what was the medication that she was tapered down on?
I believe it was Seroquel and Klonopin.
Did her intrusive thoughts and the paranoia, did that abate? Did that stop?
It did not.
Now, when she was home in the month of January after Cora's birthday, which I think was on January 7th, did she continue to have these intensive intrusive thoughts?
Yes.
Can you tell us, when we say intrusive thoughts, is she referring to intrusive thoughts like you might think of something coming up next week that's bothersome, or is this a indication, in your opinion, to a reasonable degree of medical certainty as to what she was experiencing at that point in January of 2023?
She wasn't just having everyday thoughts that we all have, reminding ourselves to do something, which we make note of, and then we move on. Intrusive thoughts are unrelenting. They don't stop. They're what we call ego dystonic. You don't want them. They keep interfering with your ability to get through the day.
Did she have, at this point, intrusive thoughts continuing regarding voices in her head that she heard constantly?
Yes.
What were these voices saying to her?
They were getting worse, and they were telling her to kill herself.
And as January continued, she was, to your knowledge, using her computer to look up drugs and interactions and side effects and things of that nature?
Yes.
If a person is in a psychosis, or as I think you said premorbidly, psychosis, are they able to do things like look up things on a computer?
Yes.
And you're aware that she actually at one point looked up, can you cure, I think a sociopath or a psychopath or something like that?
It was sociopath, yes.
Is that indicative of her feeling that she is a homicidal maniac and has to have some help, or is that in the same time frame that she was Googling all of the effects of medications on a human being?
Is it an objection?
Yes.
Yeah, sustained.
So during the period that she was Googling, well, let me ask you, what was she Googling?
Googling words about sociopath, sociopathy. Can you treat a sociopath? What are hallucinations?
What else?
Bear with me one moment, if you don't mind.
Well, you had a chance. Did you look at the Google searches that she had
Yes.
done that's in evidence and the jurors were able to look at it?
Yes.
Did she continue to Google the effects of medication, psychosis, numbness, heaviness, unable to, things like that?
Yes. All things that are related to the
And
way
if
she
a
was
person
feeling.
is in a psychotic state, are they able to continue to Google and use a computer to look things up?
Yes.
They're able to use a phone?
Yes. People who are in that state can do things they've done before. New tasks may be difficult, like changing a tire. But if you looked up things on the internet, you can look them up again. If you drove a car, you can drive a car.
Now, the morning of January 24th, I believe she went somewhere. Is that right?
Yes.
Where'd she go?
You should take her daughter to a pediatrician, a standing pediatrician appointment.
And is it your understanding to a reasonable degree of medical certainty that a person who's in a psychotic state is able to drive a car for a short distance, go to an appointment and interact and talk to people?
Yes, they can do everyday tasks of living.
So the fact that she's not talking about the unicorns in the corner and she's not slurring her speech and she's not unable to walk, to your opinion, to a reasonable degree of medical certainty, does that mean that she's not in a psychotic state?
It does not.
Would you tell us, after she took Cora to the doctors and the jurors have had a chance to look at the exhibits, there's photographs between her and her husband, Pat, back and forth. In the afternoon, what did she do?
She built a snowman in the backyard.
Did she later in that day Google directions to a restaurant, 3B restaurant?
Yes.
Is that something that a person can do when they're in that type of a state?
Easily.
Did the
Yes.
voices or the intrusive thoughts to your interview and your understanding abate or stop at that point on January 24th?
No.
Did they continue?
Yes.
And did she communicate by text with her husband about getting dinner and getting something from CVS?
Yes.
And what was it? Was it Pedialyte?
Pedialyte or Flexlax, it's a stool softener for her child.
And that's something that was prescribed by the doctor, right?
Yes.
Does that make sense that if somebody is in a state where they're having these symptoms, that they're able to remember that the doctor wanted the child to have Pedialyte and she tells her husband to get Pedialyte?
Yes, it does not interfere with that type of everyday living.
She indicated to you, sir, that that evening after the husband had, oh, by the way, was it your understanding from talking to her that the husband had taken trips, gone away for weekends, gone on ski trips, had brunches with his friends, and was out of the house on a regular basis?
Yes.
That night is when the children were killed. Is that correct?
Yes.
And we've heard repeatedly about the circumstances of the going out the window and the weather and the damages and the injuries and going to the hospital. Doctor, based on your review of all of the medical records, did you administer any testing, by the way, to her? Like you were talking about psychological testing?
Yes.
And what were the psychological tests that you performed?
Initially, I did a mini mental status exam, MMSE. It's just a common test
Wait a
about
minute.
orientation.
I'm sorry, I didn't understand that.
Oh.
NSE? What is that?
MMSE, mini mental status examination. Very common test
Okay.
demonstrating whether someone has a field of knowledge, who's the president, what direction should travel, and basic things like where are you, what day is today, who are you? And then I did another test as well.
What other test was that, sir?
That's the HARE psychopathy checklist, HARE.
What does that do?
That's a measure of antisocial personality disorder.
And do you have an opinion to a reasonable degree of medical certainty based upon the scale that you use to assess whether or not Lindsay Clancy had anti-personality disorder?
Yes.
What was the result?
The result is that she does not have any type of antisocial personality disorder, also known as sociopathy.
In addition to reviewing the medical records and testing and meeting with her, did you also interview third parties?
Yes.
Is that referred to in the psychology as collateral contacts?
Yes.
And you reviewed and interviewed a number of people in her family or friends or people in her social circle, is that correct?
Yes.
Can you tell the jurors, sir, to a reasonable degree? Well, let me ask you this. Are you familiar with Mass General Hospital doing a major research program on postpartum psychosis?
Yes.
And did they publish an article, a significant article regarding the circumstances, symptomology, and things of that nature of postpartum psychosis?
Yes.
And would you agree, sir, that the symptoms of postpartum psychosis would be depression? Is that one?
Yes.
Did Lindsay, to your opinion, have depression?
Yes.
And were there indications from your review of the medical records that she felt low, flat, tearful, emotional, crying?
All of those things, yes.
Did she also express anxiety, feeling tense, nervousness?
All of those things, yes.
Did she also express feelings that she was withdrawn, not able to socialize with people, wanting to talk or be near others?
All of those things as well, yes.
She indicate that she felt tired, heavy, without energy?
Absolutely, yes.
Did she indicate that she was having a harder time taking care of her children?
Yes.
Did she indicate that she was having issues regarding personal hygiene, not bathing, things of that nature?
Yes.
Did she indicate that she had severe confusion in actually hearing or seeing things that aren't there? In her case, it would not be seeing, that would be visual hallucinations. But did she complain of hearing things that weren't there, hallucinations?
Yes.
Did she complain of thoughts and beliefs that were not within reality and that she was in a disassociated state out of reality?
Yes.
Did she indicate that, did you observe that there were circumstances where she exhibited increased energy, activity, productivity, otherwise known as hypomania?
Yes.
Did she complain that she had racing thoughts, a quote, busy brain, end quote, increased creativity?
Yes.
And when she said in your review of the medical records that she was having a busy brain, did she express the fact that she would get confused and that she thought her brain was damaged?
Yes, that's correct.
Was she restless and agitated, unable to keep still,
Yes.
unable to sleep?
Yes, extremely unable to sleep.
So can you tell this jury, sir, in your opinion, to a reasonable degree of medical certainty based upon all of what you have reviewed, all of what we have talked about, all of what you have considered, as to whether or not at the time of this incident resulting in the killing of these three little kids, that she was suffering from a mental disease or defect, such as that she lost substantial capacity to appreciate the wrongfulness of her act, or in the disjunctive, was unable to conform her conduct to the requirements of the law?
Yes.
Tell the jury what your opinion is, please.
My opinion is that she did have indeed a mental disease or a defect. That's a legal construct, not a DSM-5 one, but she had bipolar disorder with postpartum psychoses. In addition, she was unable to conform her behaviors to the rule of law, and she had no appreciation for the wrongfulness of her act.
Thank you, sir.
You're welcome.
All right, Kamal?
morning, sir.
Good morning.
So, yesterday, when you first took the stand, Attorney Reddington asked you a little bit about your background. Recall that?
Yes.
And you, in this field of being a psychologist and a forensic psychologist, you circulate a curriculum vitae where all that is outlined, right?
Yes.
And fair to say, you testified yesterday, and on your curriculum vitae, you speak briefly about the fact that you have previously testified for the Commonwealth, you said, as well as for the defense, correct?
Yes.
You referred to defendants and respondents, right?
Yes.
And so one of the things that you've done in the past is to be what's called a qualified examiner, right?
Yes.
You are currently not actively doing those examinations, are you?
I actually have done one, but I don't actively do that anymore.
Okay. And so in those respects, is that when you say you testify for the Commonwealth, is that primarily the work that you would do where you say you testify for the Commonwealth?
Yes.
And in those evaluations that you do, is it fair to say that you're actually an independent contractor with a company that contracts with the Department of Correction on those cases?
Those are what qualified examiners are. That's correct. That's how you become a qualified examiner through the DOC.
Right. And you're an examiner, a qualified examiner, is retained or takes work in doing evaluations in order to perform independent assessments, are they not?
Yes.
So they're not hired by the Commonwealth.
They are, because the company that retains the qualified examiners is hired by the Commonwealth, and these forensic psychologists are then appointed cases to do these types of examinations. So it's under the big umbrella of the Commonwealth.
So, yeah, big umbrella Commonwealth, meaning Department of Correction, an agency that is under the seal of the Commonwealth of Massachusetts. But as far as when we talk about Commonwealth, like Commonwealth versus Lindsay Clancy, that's the prosecution. In those proceedings, the Department of Correction sometimes is the moving party, right?
Yes.
And sometimes it's the district attorney's office who's the moving party.
Yes.
But it's never the defendant who's the moving party.
Never.
And in those types of proceedings, sometimes if you opine a person is what they call sexually dangerous, you would testify for the Commonwealth, right?
Yes.
And if they're not, or if you find that they're not sexually dangerous, you'd testify for the respondent.
Yes, we're neutral.
So you're not
Testify with the
testifying
fact.
for the Commonwealth. You're, as in the prosecution, you're testifying under the big umbrella of the Commonwealth.
I think it's a matter of semantics, because if you do an evaluation and you render an opinion that this patient is sexually dangerous, when you testify, you are working with the district attorney's office and you review your case with the DA. And the way I see it is that you're testifying for the Commonwealth as an independent examiner, but on that day, you're testifying for the Commonwealth or that DA's office.
And you haven't done that work in closely a decade, fair to say?
No, that's not true.
Well, pre-pandemic, correct?
That's not true.
So when was the last time you testified for the Commonwealth, meaning the prosecution, in an SDP proceeding?
So I was assigned a case through Suffolk County, the Sexual Dangerousness Unit, by ADA, Kelly Ryan, Kelly. And I did that evaluation on July 2nd, 2026.
And have you testified at a probable cause hearing for that?
No, I wrote a report which was in lieu of testifying.
Where you opined that somebody was sexually dangerous?
Yes.
Okay. Fair to say, though, the majority of your work here in Massachusetts over the last few years is contracted with the Committee for Public Counsel Services, correct?
Yes.
And for the fiscal year of 2024, you were paid by CPCS in the open checkbook for approximately $340,000 worth of time and work.
That's about right. We get paid a fixed rate. It's a government rate that's assigned to all examiners.
And for the fiscal year of 2025, it was approximately $300,000 that you were paid through the Committee of Public Counsel Services.
That sounds about right.
You also indicated yesterday that you have known Attorney Reddington for a number of years, correct?
Yes.
Fair to say you've done quite a bit of work with him over the years?
That's an expansive term, but
It
I
just
work with
requires
him.
a yes or a no.
Yes.
And you've also testified that you have your doctorate in clinical psychology, right?
Yes.
And you testified yesterday, or you told us a lot about your military experience, but as you sit here today, you are not a prescriber of medications here in the Commonwealth, are you?
I am not.
You
And
don't have a
I was not yesterday either when I was asked about that.
Right. You told us all about your experience in the military and having that limited ability to prescribe years ago. But as far as you sit here today and in your evaluations that you do today, you don't do forensic psychiatry evaluations, do you?
That's correct, but I just want to clarify for a point of accuracy. I was not in the military. I worked for the Department of State.
I believe I said your work with the military, but thank you. So in here in Massachusetts, you conduct primarily you conduct evaluations in forensic psychology, correct?
Yes, for the most part.
And you are aware that there are particular standards for forensic psychologists working within the criminal justice system, right?
Yes, but just to be a little more clear, forensic psychologists such as myself also work for police departments doing evaluations for fitness for duty. So although they're law enforcement, they're not engaged or accused of any criminal activity.
Well, I'm referring to your role when you come into the court and you testify as you are today as a forensic psychologist. That's what I'm referring to. You're aware that there are particular standards in place by the ABA criminal justice, mental health standards is one of them, right? You're familiar with that?
Yes.
And you're familiar with the American Psychological Association specialty guidelines for forensic psychology?
Yes.
And fair to say that with those standards, they're not required, but people are encouraged to follow them, right?
I think that's fair to say.
And the criminal justice, the ABA criminal justice mental health standards actually identify the different types of roles that forensic evaluators have in the criminal justice system, including evaluating, consulting, and treating, right?
Yes.
And so, fair to say standard 7-1.3 indicates that for evaluative experts, the obligation is to make a thorough and impartial assessment based on sound evaluative methods to reach an objective opinion. Would you agree with that?
Yes.
And so, again, in the American Psychological Association specialty guidelines, section 1.02 indicates that forensic practitioners strive to be unbiased and impartial and avoid partisan presentations of unrepresentative, incomplete, or inaccurate evidence. Would you agree with that?
Yes.
Is that a standard you strive to follow?
Yes.
Okay. In this case, you indicated that you've been with the case since February 4th of the year 2023, correct?
Yes, 41 months.
And you've authored a report, you said, in June, I believe, of 2026, correct?
Yes.
But you've also offered other reports or updates of the defendant's condition over the years. Is that fair to say?
Yes.
And you provided a report, an update, I should say, in July of 2025.
Yes.
Do you recall that? And in that report, you identify that as of July 23rd, 2025, that the defendant was residing at Tewksbury Hospital. Do you recall that? Putting that in?
Yes.
And that there was a planned transfer to Worcester Recovery Hospital, or Worcester Recovery Center and Hospital. Do you recall writing that?
I don't know if it was a plan. It was a hope and a goal, but it was not a official plan.
Well, I could provide you with your report if you'd like to review, but it reads, currently, Ms. Clancy resides at Tewksbury Hospital with a planned transfer to Worcester Recovery Center and Hospital.
That
Does
sounds
that sound
right. Yes.
Okay. And that she is presently medication stabilized and is in the process of discontinuing most, if not all, psychotropic medications, demonstrating an emerging capacity to stabilize without them. Do you recall writing that?
Yes.
So in July of 2025, it was your opinion that she was stable and she would be, hopefully, as you say, transferred to a different facility, correct?
Yes.
And you're aware that currently she's still at Tewksbury Hospital
Yes.
and currently she's still taking psychotropic medications.
That's true. Yes.
I think you also write in that report, we'll strike that. Going back to your most recent evaluation in June of 2026, you would agree with me that in an evaluation for criminal responsibility, being a forensic psychologist, it's really important to be as accurate as possible in your reports, correct?
Yes.
You want to make sure you get the facts right?
Yes.
Because your evaluation is not just based on what you learn from the individual you're evaluating, but also an independent review, an unbiased review of the records of the facts. Is that fair to say?
Yes.
Okay. So in your report, you indicate that the period of evaluation that you had with this individual is approximately 45 hours. Do you recall writing that and testifying about that yesterday?
I think I actually said I've met with her a total of 45 hours, but the evaluation was more than 35 hours, and I think it was 37 hours.
Okay. And you also said yesterday that in addition to that, you've met with her several other times for a total of approximately 60 times at least.
Not 60 additional times, but in total, yes, since the court trial has started a few weeks back.
Okay. Is that typical for you to spend 35 hours with a person that you're evaluating?
It does happen, but it's not typical.
You also indicated yesterday that one of how you became involved in this case is Attorney Reddington called you and asked you to go check on the, I think you said mental well-being. Is that what your
Mental
testimony
health and mental well-being at the time of her admittance to Brigham and Women's Hospital, which was roughly late January 2023.
And your first time there was February 4th, correct?
Yes.
Were you examining her as a potential patient at that point?
I was examining her as a colleague and friend of Attorney Reddington to see how she was faring. There was no predetermined notion whether I would be interested or willing or even offered the opportunity to take the case. I was just going to meet with her, given the fact that she was in a bed in ICU, locked to the bed frame, and no one was able to visit her.
So you went in to visit her?
Yes.
And when you went in to visit her, you indicated that she had recently been extubated in your testimony yesterday. You're aware from the review of the records that she was extubated on January 28th.
Yes. So the difference between January 28th and February 4th, I didn't know the date at that time, but I knew she was able to breathe on her own and express
And you're
verbal
aware-
language. Yes, expressive language.
You're aware that she had been communicating with staff at the hospital, including psychiatrists, right?
I don't know if I knew at that time, but I knew she had been speaking with the doctors and staff,
Well,
but not specifically who it was.
a person who goes through major trauma and is at a hospital and has made suicidal attempts, in your opinion, it would behoove the hospital to have that person talk to a psychiatrist, correct?
Yes. Overall.
Yes.
Now, in addition to meeting with the staff and the psychiatry team, prior to your arrival, were you aware that she had an attorney that had came to visit her a few times. Not Mr. Reddington, but a different attorney.
Yes, I don't know how many times, but I am aware that there was an attorney, Gelb, who was somehow involved in the case.
Okay, so there was somebody that came in to see her prior to you coming in to see her.
Yes.
Now, you testified yesterday that you performed a mental status exam that day on February 4th. Do you recall that?
I do.
Where in your report or the previous report from July or your June report do you outline the results of your mental status exam?
There is none, because if someone's not capable of just explaining who they are, where they are, and if they're clear of mentation and thinking, then I'll meet with them. But if they're not, I won't. So it's a sine qua non. You do that just to make sure you can keep meeting with them and that they are able to understand what you're talking about. Standard practice.
But you indicated yesterday that she did know who she was, right?
Yes.
She didn't know where she was.
Yes.
But I believe your testimony was that she did remember what happened, but she was foggy as to what happened.
Yes, that's correct.
And she actually, according to your testimony yesterday, asked you for your phone or to access your phone to make a phone call. Is that correct?
Yes.
So she was able to communicate with you.
Yes.
She asked you for something and you clearly understood what she was asking for.
Yes.
And you indicated that she asked to call her husband, right?
Yes.
Had you spoken with her husband before that time?
I did not speak with him at that time. I didn't know him, and I had not spoken to him prior to that time.
So how'd you get the phone number to call him?
I did not have the phone number to call.
So she provided you with a phone number to dial so that she could call him on speakerphone, right?
Yes.
And she remembered the number?
Yes.
And so you indicated on that day, on February 4th, that she left a voicemail, right?
Yes.
So in that voicemail message, were you able to identify that it was Patrick Clancy's phone? Did it say, hey, this is Pat, leave a message or something to that effect?
I don't remember the salutation from the voice recording, but there was no evidence that it was not Patrick Clancy.
And as far as her confidence in the number, she gave it to you with no issue, did she not?
That's correct.
She didn't have her own cell phone to refer to, did she?
That's correct.
Or a pad of paper where all the numbers were written down?
She didn't.
You indicated that she left a message. Do you recall what the message was?
She expressed her love for him, wanted to know how he was doing, and that was pretty much it.
And again, you said that you didn't write down what the mental status exam was, but the fact that she was able to relay that message, was it clear and coherent what she was saying?
Yes, mental status exams are multiple levels. Different things are asked. If you don't know where you are, it doesn't mean you can't have a conversation with someone.
And she was able to have a conversation with you that day.
Yes.
Now, you said you went back on February 6th and met with her again, correct?
Yes.
And you guys made another attempt at calling Patrick.
Yes.
Again, did you remember the number?
No.
Did you have it stored in your phone?
No.
Did she provide you his phone number to call?
Well, it was in my phone. I could just look it up in my phone. I didn't write it down. I didn't enter his name. Either she gave it to me again, or I just looked it up from 2 days prior.
But you don't recall, as you sit here today, which it was, do you?
No.
And you didn't write a report about that interaction, did you?
I did not.
So in the second phone call, you were able to actually hear that she was talking with Patrick on the other end, right?
Yes.
And at that time, when you were now second time meeting with her and having this phone call, were you aware that she had already changed her healthcare proxy from Patrick to her parents?
I did not know that.
Did you talk to Patrick in between the 4th and the 6th to find out if he had tried to come in to visit her?
I didn't speak to him at all, so I knew nothing about what his plans or intentions were.
Your testimony yesterday was that she had called him to tell him that she loved him and to see where they were at, right?
Yes.
That was your testimony? Meaning what, their relationship?
That I made no interpretation of what that meant. She left the message, and we left it at that.
But in that subsequent conversation that you were a witness to where they were speaking on the phone and she told them about these voices or explained about the voices, did she ask about the kids?
She did not, as I recall.
Now, in all of the times over the course of the last few years that you've met with Miss Clancy, how many times has she told you since the incident that she's heard a voice? Currently.
She has not heard voices since the event took place in 2023.
And you've now testified that over the course of a period of time that she did hear voices, right?
Yes.
And is that based on one of these 35 hours worth of conversations you had with her? How do you know that?
Well, they were collateral contacts. Spoke to other people. I spoke to other people who I asked the nature of their interactions with Miss Clancy, and it was not a fishing expedition. I asked them if they can tell me what happened.
Well, I'm asking you.
But they disclosed, pardon me.
You have to let them finish.
So they disclosed information to me that Miss Clancy shared that information with them.
So who did she tell that she had a voice that told her to kill herself?
She spoke to a chaplain named Sheila Kavanaugh, who I spoke with, and Chaplain Kavanaugh told me that Ms. Clancy told her that she heard a male voice instructing her to first kill her children and then to kill herself.
So the same message that she delivered to Patrick that day on the phone, you heard from a chaplain at Brigham and Women's Hospital after the incident occurred in January of 2023?
Yes.
And so from all of the records that you reviewed of her treatment and all of the interviews with her family, who did she tell that she heard voices telling her to kill herself?
I believe she told family members.
Which family members?
I believe she may have said that to her mother. She, I believe, told her husband that she felt like killing herself as well.
In the records with the providers, you're aware, you've reviewed them all and you've sat through all of their testimony. You're aware that when she described intrusive thoughts, she never referred to them as a voice telling her to kill herself, did they? Did she?
No, she was referring to...
It's just a yes or no?
No.
So as far as her reports of these intrusive thoughts that appear over and over in the notes, you would agree that it was simply, when asked about what they were, it was simply that she felt like she wanted to die, right?
Yes, and...
It's just a yes or no?
Yes.
Now, in your report, you go through what's called the sources of information. You're familiar with that part? It's pretty standard in a forensic report, right?
Yes.
Where you list all of the things that you've gone through and reviewed in compiling the information for your report.
So in my sources of information, I reviewed the following, but that list is not limited to the following. So there might be other pieces of information that I may have reviewed, but didn't put in the list.
Okay, so not on the list are the Tewksbury Hospital records that you said you reviewed recently, correct?
Yes, the 7,000 pages of those hospital notes. I didn't review all of them at the time of the report.
Did you review records from the Spalding Rehab Facility?
Yes.
That's not contained, though, in your list, in your report, is it?
I don't think it is.
And you don't cite to any of the Spalding Rehab records in your report coming to your ultimate conclusions, do you?
I do not.
And how about the women and infant records? Did you list that in your sources of information section?
I do not. She was there for 1 day.
Okay, but you've testified about that, right?
Yes,
Did you review them at all?
yes.
And as far as the McLean records, you don't list the McLean records as a source of information in your report, do you?
I did not, but I did review them.
Now, you've described, and you describe in your report, that you believe that Ms. Clancy was hypomanic, right?
Yes,
And I believe you testified to some extent, and you've written in your report that you identify her as euphoric, excessively energetic for 3 months postpartum. Do you remember writing that in your report?
yes,
That you note that she exercised early, right?
yes,
But you're aware that she exercised pretty frequently before birth
yes.
and while pregnant with Callan.
And while post-pregnancy with her children as well, yes.
So it was part of her routine, fair to say, right?
It's part of everyday living. Things sometimes change when you have a baby, and a few weeks later, if you're still doing the same exercise, it's sometimes a reflection of something other than committed to fitness.
And you identify what you refer to as a marketing scam, being that Beachbody business, right?
Yes,
But you're aware that that's a series of workouts and a line of nutritional shakes and exercise plans that millions of people engage in across the country.
yes.
So it's not a scam. It's just a way of
That's
a
the way to-
lifestyle choice.
If you do something for marketing and you lose all your money and there's no effort
Well,
to
did
get
she-
that back, it's a scam.
Yeah, you've asked them, you can kind of figure
Sorry.
out what its definition is, so.
Did she tell you she lost money with the Beachbody?
Yes,
When was that?
it was summer of 2022 after her third child was born.
No, when did she tell you that
When
she
did
lost
tell-
money?
I don't recall that.
And is it in your report?
It may be, but I'm not sure.
Well, I have it with me, or do you have it up there? Can you look and point to me where she told you, at what point she told you she lost money in this endeavor?
I don't know where it is. If it's here, it didn't seem relevant whether she lost money in a scam after her child was born
Well,
in terms of the big picture of what we're here for today.
you've described it as a scam because you said she lost money. So wouldn't it be important to know if she actually lost money?
I don't really think so.
Okay. You also identify the 5-mile race that she completed. Was it a 5-mile race or a 5K race?
Well, I wasn't sure which it was. I was told initially it was a 5-mile race. After my report was submitted, it may have been, with reflection, a 5K race.
And you've sat in the courtroom each and every day of this trial, so you've heard all the testimony about the evidence, right?
Actually, I've not been here every day, but I've been here most days, yes.
You're also aware that prior to the kids being born, that she considered herself a runner,
Yes.
right? She had a treadmill at her house. She went to the gym and used the treadmill. She ran other races.
Yes.
Now, in your report, you indicate that part of the timeline of her medication and her decline is the September time period where she was prescribed the Zoloft, right?
Yes.
And you indicate that she had reported, and it's reflected in the records, that she increased the Zoloft, and that's when she couldn't sleep for 48 hours straight, right?
Yes.
And you're aware of what the instructions were, having reviewed everything in this case, what the pill bottle said as far as the plan for the Zoloft?
I'm not sure specifically the incremental plan to go from 25 milligrams to 50 milligrams of Zoloft.
I have the bottle, exhibit number 2, sertraline, not Zoloft, right? Brand name Zoloft.
Yes.
Says take 1 oral tablet once a day for 1 week, then increase to 2 tablets daily thereafter.
Right.
Right on the label.
Right. That's 25 milligrams to 50 milligrams.
And again, having been at the majority of this trial, you aware that there were 30 in that prescription and 23 left in the bottle when they were inventoried.
Yes.
And those are pills that were in Patrick Clancy's possession at the time of these events in January. You're aware, right?
Yes, I believe they were in the middle console on the lower part of his truck, the lower part of the middle console in his truck.
So if there's only 7 pills missing from a prescription that requires the person to take a particular dosage for 1 week or 7 days, how did she double the dose?
Well, sometimes when you are given medication, you may have medication of the same exact dosage and the same exact medication another time, and you therefore may have pills that you didn't take the previous month or the month before that, and sometimes people just finish what they've had before and before they go on to the most current dose. So I am aware of what you're referring to, but I don't know if there are other bottles there that she may have had medication still in those pill bottles.
Well, I'm looking at exhibit number 1, a record from CVS Pharmacy, which all of these bottles are from. And the only time a prescription for sertraline is filled is on September 15th, 2022 for 30 pills. You aware of that?
Yes?
So there's no prior prescription for sertraline, is there?
I don't think so.
Now, in your report, you also refer to 1129, and your report on page 8, paragraph 2 says on 1129, Paula Gelada. Is that supposed to be Rebecca Gelada?
Yes.
Okay. So it also says that she prescribed Seroquel to treat Miss Clancy's anxiety, depressed and unstable mood, and psychotic symptoms of disassociation and derealization. Where is that in Rebecca Gelada's record that that's why she prescribed Seroquel?
I'm not sure.
And in fact, you were present when Ms. Gelada testified and said that she prescribed it at 25 milligrams for insomnia, not for anxiety, depression, unstable mood, or psychotic symptoms. Did she not?
It's used off-label. It's sometimes medications are made for many things. Sometimes they're used off-label, not for what they're prescribed for. So that's a medication that is used for sleeping, although it's an antipsychotic.
You're aware from reviewing the records and hearing testimony that that initial prescription was for a 25 milligram dose, correct?
Yes.
I know you're not a prescriber, but you're aware that a dose for treatment of bipolar is significantly higher than 25 milligrams.
Yes.
Now, you've described in your testimony in this court repeated auditory hallucinations about wanting to kill herself or that she should kill herself and that she is damaged or her brain is damaged, right?
That's correct.
Now, did you have a conversation with her in one of these 35 hours about that particular voice or thought or belief?
So when I meet with Ms. Clancy, it's not as if I have one conversation on one of the 35 hours. To have thoroughness and exactitude, one does what we call intra-rater reliability. In other words, over the period of time, to confirm what someone says to you to help endorse the veracity or accuracy of that, you'll ask that question in a multitude of different ways. So I don't just ask once, did you hear a voice on that day? I asked in different ways over time, and her answers pretty much remain the same.
So when you quote in your report, when questioned about the nature and content of these horrible thoughts, Ms. Clancy stated, quote, like a really bad and intrusive thought that I didn't feel like it was mine, telling me I should kill myself, your brain is damaged, you're never going to get better, end quote. Where does the quote come from?
Where's the quote come from?
Right.
She had said that to me.
To you at some point.
Yes.
Okay. And this is well after the incident occurred, correct?
Yes.
And you reviewed all the records to know that she did not endorse that she was hearing a voice to any of her providers between September and January 23rd of 2023.
So when someone,
Yes or no, sir?
that's a difficult question to say yes or no from, because sometimes if someone says something that's inaccurate, it's not an affirmatory or a negative response. That's misleading.
My question to you, though, was where in the records from September to January 23rd or 2022 did she tell any of the providers she saw that she heard a voice telling her to kill herself?
It's not in the records.
Okay. And you're aware that she has spoken to several forensic psychiatrists and psychologists over the course of this case, right? Not just yourself.
Yes, she spoke to 3 retained experts in April 10th and April 12th of 2026. And then on June 12th of 2026, 1,172 days after I initially met with her, then 1,1220 days after I met with her. That's the third examiner.
Well, you're aware that you're referring to Dr. Halbrin, Dr. Mack, and Dr. Satoff, correct?
Correct.
But you're aware that she also spoke with Dr. Resnick and Dr. Spinelli well before that.
On May 5th of 2023, approximately 90 days more or less later. Yes.
And you're also aware, sir, that she never told Dr. Resnick in a recorded interview, nor Dr. Halbrin, Dr. Mack, or Dr. Satoff that she heard.
Sustained.
Your testimony is that she told you that she heard this voice. Fair to say she identified to you that it was her own voice that she heard, correct?
That's not correct.
So she told you that she heard a male's voice?
That's correct.
When?
On the night of the incident, January 24th, 2023.
No, I'm referring to the fact that you've now testified that she heard this, as you call it, a persistent what's the word you use? Persecutorial voice over the course of time? Was that your testimony?
So you're referring to the ongoing negative voices or intrusive thoughts that she was hearing,
Right.
where she felt, in fact, other people could hear those voices, thought broadcasting. So there are multiple layers here of hearing intrusive thoughts.
So, but I'm not.
Hearing voices so loud that she believed other people could hear her. Those are 2 separate phenomena, if you will.
In those voices that you're saying she told you she heard about wanting to die or to kill herself or her brain was damaged prior to January 24th of 2023, did she say it was her own voice she could hear? It was her own thoughts?
She did not identify whose voice it was.
Fair to say the only time she specifically said she heard a male voice was when she recounts the events on January 24th of 2023.
Yes, that's accurate.
And you'd agree that there's a difference between the idea that somebody believes their thoughts would be or could be heard by others and the belief that they are being heard by others, right?
Yes, it's a matter of semantics, and it's a level of degreeism. Believing and knowing, 2 totally separate things.
And believing, having a fixed belief like that would be a delusion, right?
That's correct. A delusion is a fixed false belief that is unshakable and not something you get rid of either through your own efforts to tell the voice to go away or other people saying, just, for example, try to stop thinking about it.
And the idea that she believed that something was wrong with her brain, or that if people could know what was happening, that the police might get involved, That is something that could happen if somebody articulates those things, right?
Absolutely. It's common sense.
Now, in your report, you also indicate that, in your testimony, you indicated that on January 5th of 2023, that's when Ms. Clancy was discharged from McLean Hospital, and I think your testimony was that she went in there on Seroquel and I think you indicated Klonopin, correct?
Yes.
And your report says Seroquel and Klonopin. You recall that?
Yes.
You're aware that based on the medication journal that is in evidence that she hadn't taken Klonopin since November 27th of 2022.
She had a prescription for that, and I think she may have taken some, but may not have been on a regular basis.
But you've seen the pages of her journal to know that she's pretty diligent about saying exactly what she took on each particular date.
Yes.
Leading up to her stay at McLean and even after.
Yes.
Now, kind of sticking with these medications for a second, you have testified, I think this was yesterday, you testified that you were familiar that after Dawson's birth that she had sought some medication, correct?
Yes.
And I believe you testified yesterday that she was on trazodone, but in fact, she was prescribed Zoloft after Dawson
Yes.
and reported she did never take it,
That's
right?
correct. So after my testimony, I reviewed that and I confabulated the trazodone with another medication, the Zoloft.
And again, you've talked a lot about that the medications that she was taking, the different medications, didn't provide her with any sort of relief. So it's important to know the different medications she was taking and what the reactions were, right?
I don't know if I talked a lot about it. I was asked questions. I answered them honestly. They didn't provide relief. I would agree with that. And that was the whole point of her seeking help.
And her history, whether it be medication history, a social history, a family history, those are all important things overall for you to look at and examine when coming to ultimate conclusions, right?
For everyone, yes, of course.
So it's important to be accurate when you're recalling or reporting that information.
As much as possible as one can be. Yes, that's true.
And as far as the medication goes, I think you testified yesterday that she also took medication in nursing school, correct?
Yes, she did.
And having met with her as many times as you did and reviewing all these records, you're aware that those were in fact Prozac, Wellbutrin, and Propanol that she took in nursing school.
That's correct. That was for her what's called glossophobia, GOLLOSPHOBIA. It's fear of public speaking. Most common fear for Americans. 85% of Americans have public speaking phobia. Pretty commonplace. But yes, those are the medications she took while she was in nursing school to go through the program.
But that's not what you testified to yesterday.
I think I mentioned only one or two medications, had taken 3.
Okay. And you also mentioned today in your testimony, you were asked about the date of December 15th. And I believe your testimony was that's the day she went to Women and Infants.
I believe so, yes.
If I show you the record, is it fair to say she didn't go to Women and Infants on the 15th, but it was actually December 20th?
Right. I believe she went to the Mass General Hospital ER on the 15th.
And you said in your testimony today that at the Mass General ER, she did not get any help. Do you recall that testimony?
She declined admission to the inpatient. She didn't want to do that. So,
You didn't not get help.
so
Go ahead.
thank you, Your Honor. We have something called the subjective baseline, the cognitive appraisal theme. Help is in the eye of the beholder. If she felt she didn't get help, that's how she felt.
Well, sir, that wasn't the question. And your testimony was she went to the ER and did not get help. That was your testimony, not hers.
Well, my testimony is based on my evaluation of her. This is what Ms. Clancy shared with me. Who am I to doubt what she believes or doesn't believe about the offer for treatment or help? It's her opinion.
She chose to decline the bed at McLean on December 15th, did she not?
Yes.
And she then indicated to the Mass General Hospital that she was going to opt for an outpatient program at the Women and Infants, correct?
Yes.
That's what's in the records.
Yes.
And did she tell you that as well?
Yes.
And as it pertains to the Women and Infants, again, after you review the records, you're aware that a referral had been made to her well before her visit to the ER on the 15th for that same program.
I believe so.
Now, you've indicated in your testimony that it's your opinion that her diagnosis is bipolar disorder with psychotic symptoms, correct?
Yes.
And fair to say, you've reviewed, prior to your report, you had reviewed Dr. Resnick's report.
I'm not.
Can I see counsel sidebar? Go ahead, counsel.
So the question, I believe, was, did you review a report of Dr. Resnick in all your sources of information and before you came to a conclusion about diagnosis?
No, I did not.
Well, One moment, sorry. On page 4 of your report, where you,
One second. Okay, I'm sorry, Council.
on page 4 of your report, where you list the sources of information, you do identify as number 24, forensic psychiatric evaluation of Philip J. Resnick from 9/27/24, do you not?
I do.
And so that's something you reviewed.
I didn't draw my opinion.
That wasn't the question, sir.
Well,
All right, hold on. Ask the question again. Go ahead.
Did you review his report?
That's not the question.
So the question, sir, is did you review Dr. Resnick's report prior to authoring your report or coming to your conclusions about diagnosis?
I reviewed part of that report. And in my report, I perused through the reports. I did not review all of that report from Dr. Resnick or Dr. Spinelli for that matter.
Okay. Now, in talking about your review of records, you indicated that there are several thousand pages of Tewksbury Hospital records, correct?
7,001 page.
And did you review all of those?
I would say I looked through them, but I did not read every word on every page. They do have a tendency to hang together and are replicative as well.
Were you aware that on May 26, 2023, that the defendant was observed by staff in a note stating that she was visible along the unit hallways, self-propelling her wheelchair with her one-to-one staff? She had a visit with her mother who brought dinner for her. They ate and played games during the visit. Are you aware of that?
On May 26th.
May 26 of 2023.
May 23. So 3 years ago and a few months. I don't know that. I don't remember.
That would have been approximately 4 months after the incident and on the date of Callan's first birthday, right?
Yes, but you asked if I remember that event, and I don't.
You don't, or you do?
I don't remember that she was seen with her mother on that day who brought food, and she was seen using a wheelchair to travel down the hallway at the hospital. I don't remember.
If I tell you that was read from page 176 of the Tewksbury Hospital records, would you agree with that?
I would not doubt that.
And on December 24th of 2023, were you aware that the defendant was observed at Tewksbury, monitored on one-to-one for safety, that she accepted medication, meals, and snacks? She spent time in the TV room or sitting outside her room, utilizing phone, and visited with family. Do you recall that, reading that note on page 613 of the Tewksbury records?
Of 2023?
Yes.
Honestly, I don't.
And that would have been Cora's birthday.
Okay.
But would you agree with me that if I read that from page 613 in the records, that would be within that 7,001 page of the record?
I would not doubt that.
How about on January 24th, 2024, where she's observed in a note from Tewksbury State Hospital on page 674, saying, where the note reads, patient was visible in the milieu, engageable with both staff and select peers. Patient accepted select medications as her baseline, that she was pleasant during interactions, self-propelling in wheelchair in the halls, spending much of the morning and early afternoon in her room and hall on her electronics. Do you recall reading that record?
Not specifically.
And January 24th, 2024 would have been the year anniversary of the incident, correct?
Yes.
But if I read from page 674, you would agree with me that that's part of the Tewksbury record.
Yes, I believe it's part of the record.
And on, May 26th of 2024, from page 922 of the Tewksbury record, patient monitored one-to-one for safety. She's been monitored for high suicide risks, accepted medication, says BFK and snacks. She spent some time in the TV room or sitting outside her room utilizing phone. Would you agree that that's a fair reading of page 922?
I have no reason to doubt that.
Okay. And that she's also observed on that same day, visible on the unit while utilizing her phone outside her room, was able to make her needs known appropriately. Patient was observed playing dominoes with peers in the TV room. That was later in the day on May 26, 2024, which would have been Callan's second birthday.
I would believe that that record's probably accurate. I don't remember looking at that record specifically.
How about on September 30th of 2024, page 1229 of the Tewksbury record, where it's noted that she was visible in the unit, attended startup/coffee group, she was assisted with ADLs as needed. She was in safe behavioral control for the duration of the shift. And that later it reads, patient visible in the hallways, seated in her wheelchair outside her bedroom, using her cell phone, pleasant upon approach, social with select peers. That would have been on September 30th, 2024, which would have been Dawson's 5th birthday. Do you recall reviewing that in the record?
Not off the top of my head, but I have no reason to doubt that it's not an accurate record.
December 24th, 2024, page 1442 of the Tewksbury records. It says the patient was visible on the unit utilizing her phone. Her parents were in to visit and they brought dinner with them. Patient accepted medications and fluids. Patient in good behavioral control, maintaining safety. No SIB noted or reported. What do you have reason to doubt that that's on page 1442 of the Tewksbury record?
I have no reason to doubt that that's not an accurate reflection of what took place that day.
And what's SIB?
Self-injurious behavior.
And so December 24th, 2024, that would have been Cora's 7th birthday, right?
Yes.
So January 24th, 2025, from page 1514 of the Tewksbury records, where it reads inpatient treatment goal, to work on my mental health and to feel better. Says she participated in morning ADL routine with staff assistance. Patient was visible on the milieu at times in the hallway utilizing her phone. No SIB has been reported this shift. Does that, do you have any reason to doubt that that's contained on page 1514?
I have no reason to doubt that.
And the further observations on that day were that the patient was visible on the unit. She was social with select staff and peers and also seen utilizing her phone. Her parents were in to visit and brought her dinner, and they brought dinner with them. That was, again, on January 24th, 2025, which would have been the second anniversary of this incident, correct?
Yes.
May 26, 2025, page 1782 of the Tewksbury records. It says, she did not engage in any SIB. She was visited by her parents this shift. She attended startup group and watched TV. That would have been on May 26, 2025, which would have been Callan's 3rd birthday. Do you have any reason to doubt that in the record?
I have no reason to doubt that.
And on September 30th, 2025 of the Tewksbury record on page 2056, reads, patient was visible in the hallway using her phone. No SIB or behavioral issues observed or reported. Do you have any doubt? Do you have reason to doubt that that is an accurate read of page 2056?
I have no reason to doubt that that's not accurate.
And that would have been September 30th, which would have been Dawson's 6th birthday, right?
Yes.
And on December 24th of 2025, page 76 of the patient notes in the Tewksbury Hospital records, it reads, ate breakfast, refused lunch, took snacks, utilizing phone, assisted with ADLs, spent some time in the TV room, attended PT, resting in bed after lunch. Do you have any reason to doubt that is contained within the Tewksbury records on page 76?
No.
And December 24th would have been Cora's 8th birthday, correct?
Yes.
And on page 152 of the Tewksbury records, January 24th, 2026 of this year. Patient observed for safety, assess mental status, encourage safe behavioral control, monitoring for abrupt behavior change and attempt to prevent escalation or self-harm, encourage patient to participate in groups. On this particular day, she was also observed compliant with meds, ate breakfast, participated in coffee group, visible in the hallway utilizing her phone, later visited with parents, and had an early lunch. That was on January 24th of 2026. Do you have any reason to doubt that's within the records?
No.
And that she was later observed to not have any SIB or behavioral issues, again on January 24th, 2026. Do you have any reason to doubt that's contained within the Tewksbury records?
No. No.
And again, you reviewed or looked at some of them, but not every one of these. But these are already currently in evidence, correct?
Yes.
Your Honor, I would move to admit these excerpts as the next exhibit, please.
Any objection? Go for it. All right, that may be admitted. Okay, thank you.
And Dr. Zeisel, as far as the records that I just read in, do you know if in those records it indicates that she slept well on all of those occasions?
I wouldn't know. I don't know how.
Well, you would agree that noting her sleeping habits based on this particular individual's history would be an important thing for the hospital to monitor, correct?
I would agree with that.
Now, in this particular case, well, let me ask you, are you familiar with the concept of confirmation bias?
Of course.
And fair to say it's pretty prevalent in most areas of science and forensic psychology and psychiatry, correct?
It courses all domains of work and life.
And as far as confirmation bias for psychiatry or providers, fair to say that clinicians are warned that they may lean towards or support their own theories and overlook contradictory evidence. Now you have to be aware of that, correct?
Yes.
And again, in forensic psychology, the goal is to render an objective opinion, right?
Yes, the facts come to you. You don't go to the facts.
Okay. And there's a danger for clinicians and forensic psychologists of quickly forming an initial diagnosis before having all the information, correct?
Yes.
And that confirmation bias accounts for the fact that a lot of times people, clinicians and providers will cling to diagnoses and interpret subsequent information in light of that kind of already perceived idea. Is that fair to say?
They cling, I just want to make sure I understand what you're saying. They cling to a diagnosis?
Well, once a diagnosis is reached, they cling to that diagnosis when interpreting subsequent information.
That happens, yes.
And, but you would agree that in practice of forensic psychology that it's important not to do that, right?
Particularly with the guidelines of criminal responsibility where you don't need a diagnosis. You just need a mental disease or defect.
But diagnoses are helpful in understanding whether the person was suffering from this legal construct of a mental disease or defect, correct?
That's fair to say.
And it's fairly accepted in the field that if somebody has a disorder or a diagnosed mental illness, that they then in turn suffer from a mental disease or defect. Or could.
Or could, because you can have a phobia. Doesn't mean you have a mental disease or defect. If you're afraid to jump out of airplanes, it can make you ineffective and have a defect or a disease. So yes, it
Can I
could.
ask you to keep your voice up?
Yes, Your Honor. So it could, but it doesn't always have to.
Thank you.
Of course.
And you're aware of the danger of this idea of confirmation bias of having multiple relationships and conflicts in this type of work, correct?
Yes.
And that's why it's important not to be treating somebody as a patient when you're also evaluating them for this type of legal issue, right?
Of course, you cannot be the therapist and the examiner. The therapist is an advocate. The examiner looks for the truth.
And do you recall in this case submitting recommendations to the court in November of 2025 about the defendant regarding accommodations for her?
I know in general, but I don't know specifically what those accommodations requests were. I can't remember them.
But you authored and signed a letter dated November 13th, 2025 to the court, correct?
Yes, but I'm saying I don't remember specifically what those recommendations were. I know I did that.
I'm not asking you that. I'm just asking if you wrote the letter.
Hold on, just ask a question. Doctor, if you listen to the question.
Yes, sir.
I'm asking if you wrote the letter, sir.
Yes.
And in that letter, you refer to providing essential clinical findings regarding the transportation of my patient, Lindsay Clancy. Do you recall writing that?
Yes.
And so at various points throughout over the years of this case, you have referred to it as your patient, have you not?
I wouldn't be, I think, able to define her as something else. She was a patient who I did a forensic evaluation of.
Well, you referred to the court outside of this evaluation you're testifying about to her as your patient in this letter from November 13th of 2025.
Right. I evaluated Ms. Clancy, who was a patient. If I evaluated her, then she's my patient, as she is other doctors' patients at Tewksbury and other places that she's been at.
But you call her my patient in the letter.
I wrote the letter. Whose patient would I be referring to if I'm speaking about Ms. Clancy, given that she's my patient? Yes, I wrote she was my patient. That's correct.
And you're aware of, again, the APA guidelines on forensic psychology, where it warns therapeutic forensic role conflicts. Providing forensic and therapeutic psychological services to the same individual involves multiple relationships that may impair objectivity and or cause exploitation or other harm. You're aware of that, section 4.02?
Yes.
And in this particular case, since the beginning, you've appeared regularly in court hearings, right?
Yes.
You've appeared with Attorney Reddington at arraignment proceedings,
At his request, yes.
both here and at Tewksbury State Hospital, where you were sitting next to the defendant.
Yes.
And you also, on February 8th of 2023, participated in a news conference, did you not?
Yes.
It was outside the courthouse here.
Yes.
And you gave an interview with the Daily News where you commented on this.
I just
Clancy?
made a comment. That's correct.
And at this time, Your Honor, I'd like to play a clip of the news conference, please.
Mr. Reddington? Why not? All right. Thanks.
Past few days, multiple hours each day. What I can say without going too far is that her affect is absolutely flattened. She's in a very surreal state. It feels dreamlike to her, as she's described to me on multiple occasions. And individuals who can present as being lucid, linear, and clear thinking do not make those people not mentally ill. They have the capacity for, on occasion, to be able to do things that they've been doing for a long period of time. When you have delusional thinking, fixed beliefs that are unchangeable, and hallucinations, namely command hallucinations, telling you to do things, telling you to do things that are malevolent, and you believe those voices that are telling you you need to follow what they say, that's when things go downhill behaviorally, psychiatrically, and familially. And that's what we see in the most tragic of cases, where individuals who could be healthy and normal, and quite frankly, because they're paranoid and worried about what others think, they hold back on what they share. And in some cases throughout the country and the world, these are people who one day will be functioning well, but because they have the onset of command hallucinations, which they hear to, and they believe the voice that they have to do something, that's when tragedy occurs. And I think that sort of is under the overriding rubric that this case falls under.
So, sir, on December 8th of 2023, when you provided that, your observations, you had met with the defendant on 2 occasions, correct?
I believe 3 occasions.
Okay. Had you any of the records that have been presented in the course of this trial?
No.
Any of the records that are listed in your sources of information?
No.
And as you sit here and testify today, you've testified to the same conclusions, correct?
What I said was individuals like that present this way. I was not referring to Ms. Clancy. I said individuals who have these symptoms, like the ones I clarified, present that way. That was not an assessment of Ms. Clancy. That was an assessment of people who go through major mental health crises.
But as you sat here today, you've talked about the fact that she had delusional thinking, the fact that she had command hallucinations, the fact that she believed that these voices and that she was paranoid and worried. You've consistently testified about that throughout the course of yesterday and today, correct?
So
it's a yes or no.
You make it impossible to answer that question.
All right, the next question.
In addition to Well, you testified today that a person in a psychotic state can do things they've done before, but it might be hard for them to do new tasks, right?
Yes.
So if it's something that is part of their daily life, getting up, caring for the kids, feeding, making a meal, driving a car, those are things that people do every day and a lot of times don't even have to think about, right?
Yes. No thinking necessary. It's a
But you're
visual response, automatic response.
You're aware that on this particular day of this incident, on January 24th of 2023, that the defendant took Cora to the doctors, right?
Yes.
And you indicated in your testimony today that it was for a regular checkup, but in your report, you identified that it was for a stomach ache, right?
Yes. She had a stomach ache.
But in addition to maybe her having a stomach ache, she had previously had this visit scheduled, and you're aware of that now, correct?
Yes.
And at the doctor, there was a recommendation made for an over-the-counter medication, right?
Yes.
And the defendant was able to process that information, take it back with her, and then later, not immediately after the visit, but later in the day, search for where to get that medication, right?
Psychosis doesn't lower your intellectual functioning, so you can do all those things. So
Well,
that's
that
correct.
wasn't my question. My question was, did she do those things?
Yes, so that's correct.
Okay. And would you've talked a lot about that a person can operate as normally as they can, but fair to say, if you're in a psychotic state, that person themselves has a significant amount of distress, right?
Yes.
And that in order to mask those symptoms, it requires an enormous amount of control. Does it not?
It depends on the level and the extremism of the psychotic processing. So some people will hear voices that are nominal, they whisper. Some people hear voices that are yelling and screaming. So it's on a range, it's a continuum. So the more upsetting, more powerful, demanding the voice, the more difficult it might be to resist it and do other things. The less, the easier it is.
In all of the time between September of 2022 and January 23rd of 2023, at any point in which the defendant heard these voices about harming herself, she didn't act on them then, did she?
That's correct, yes. She did not act on those. She sought help instead.
One moment, please. Your Honor, I would move to admit the recording played as the next exhibit.
I'm sorry, this is the what?
The recording that was played, I move to enter it as the next exhibit, please.
That may be admitted.
If I can find it. Here it is. Thank you.
284.
Thank you.
I have no further questions at this time.
Let's talk about confirmation.
Can I sit down, please?
Oh, hold on. But Ms. Buckingham,
Thank you.
have a seat.
Confirmation bias. In the field of forensics, interface of science and the law, trial of cases, hiring experts, having people give an opinion that a jury is going to listen to. Confirmation bias means that the individual might want to help out the person that they're testifying for. Is that right?
It can be, yes.
So in other words, if you have a shooting case and you're a ballistics guy, and without the ballistics showing that the defendant's gun shot the victim, the government has no case. They may send an email to that witness and say, hey, I really need your help here. And that might influence them, right?
Yes.
Now you got involved with this case, as you indicated, out of but my request, obviously,
Yes,
compassion.
correct.
The fact you had a young lady that was literally in extreme condition, emotionally, physically, you went to speak with her, correct?
I did, yes,
Do you care for her?
I do.
And is that a violation of the canon of ethics for professionals like you if you care for your patient?
Not at all. Within the ethical standards, it's also noted to do a appropriate and meaningful forensic evaluation. It's strongly suggested you develop empathy and rapport. And when you have those two psychological constructs, you get more information from the respondent. You do not cherry pick the information. You include warts and all in your report. That avoids confirmatory bias, and you avoid confirmatory bias by also not looking at conclusions that other examiners come up with when they render their opinions, and you do your evaluations independent of anyone else. You do it by yourself.
How many times did you see her?
At the time that my report was
No, right about now.
60 times.
How many hours have you put in sitting with Lindsay, either in the hospital or evaluating?
More than that, roughly.
And you have all of that information that you have brought here today to testify to this jury. Is that correct?
Yes,
Are you confirmed bias? Are you not telling the truth just to help Lindsay out, or is this your opinion based upon your review of the records, your interview of her, whether or not you care for her or not?
Overruled.
I am telling the truth. She
Yeah. You can re-ask that question. That answer will be stricken.
So you can't tell someone you're telling the truth, and say that's up to the jury to decide. Your opinion is based upon all of the times that you met with Lindsay, right?
yes,
All of the documents that you've reviewed, all of this, all the exhibits, everything you're aware of, right?
yes, as well as collateral contacts.
And in the course of your treatment and evaluation of her, one of the things the DA asked you about is the request that we brought to the court for accommodations. You recall that question from her?
Yes,
And is it your understanding that the request that we had seeking help from the judge was that she not be chained to a van when she's brought into this courthouse
Objection.
No,
for the
overruled.
5-week trial?
yes, from Tewksbury to Plymouth.
And her medical condition with her paralysis and all of the rest of the bodily functions that you lose, that's a concern, isn't that right?
Very much so, yes.
And we also had to have the help of nurses that would be available in the event that there was any type of emergency issue, correct? That we had to ask of the
No,
court.
overruled.
Yes, they're here every day.
So confirmation bias, can you tell this jury, is your opinion based upon money? Maybe you like me, maybe you want to help her, or is that based to your best ability as a professional of many, many years?
Yes. Confirmation bias is coming up with a conclusion before you reach an opinion. It's in Latin, a tabula rasa, a blank slate. You draw no conclusion. The conclusion finds you. And if you don't do that, you are at risk of having confirmation bias.
I'm going to ask you a hypothetical and see if the hypothetical fits within your understanding as an expert of confirmation bias. Let's say hypothetically that a young woman is involved in an incident such as this that results in the death of her 3 babies. And that young woman is paralyzed. And that young woman is in a hospital. That young woman is facing indictments for triple homicide. And the incident occurred on January 24th, 2023. And it's not until 2026 that the district attorney's office hires 3 doctors.
Fiction.
Sustain.
Sidebar?
You've been sitting here for a little bit. We're going to take a short break at this point, give you a chance to take a break, and then we'll come right back and we'll continue with the testimony of this witness. Okay?
All rise, please. Your Excellency.
Jurors, tonight's the decorum, this court's in session.
All right, we'll be in a short recess at this time. Thank you.
All right, then. Well, I wasn't going to pop on, but there's a couple things that I thought maybe were worth chatting about.
Good morning. Is it still morning? Yeah, barely. So this is going to mess up the whole schedule. You know that because they're going to, break for 1 o'clock lunch. They may barely be back by then. Who knows? This may become an extended lunch hour or a shortened return, coming back maybe 1:30 instead of 2. But Judge Sullivan's been pretty solid on his break times. So we'll see. We'll see how it goes. Anyway, so what'd you think? How'd Dr. Z do on the interesting cross-examination? I mean, you can tell where they're going or where they're trying to go. Some of it, it's a head scratcher for me. Let me just go through a couple of points I thought were interesting. I don't think there's anything in the final, continued direct. Really wasn't anything except, of course, Dr. Z presented his ultimate opinion. And we'll talk about that a little bit later on. I'll get a chance maybe to re-rack that. Just because it's the ball game, mental disease or defect. His opinion, yes, she was suffering from mental disease or defect at the time of the incident in which the 3 children were killed. I mean, that's the ball game. The thing is, jury doesn't have to believe that. I mean, those are the magic words. Jury doesn't have to believe that. They can just say, not buying it, not buying the psychosis, not buying the voices thing because she didn't tell enough people about it. So the argument from the defense is going to be, don't hold against her what she didn't say to others because she did say it in the times in which Dr. Z has testified. And it was said, second or third hand. The jury could dismiss that and say, no, it's too convenient. She just said those things at that time because she's clever and she knew that it would help support her defense. We don't know what the jury's going to believe. We don't know what they're going to focus on or not. So I think it's easy for us. Obviously, if you look at our chat and the folks generally following us, we're not a defense-oriented channel per se. We're kind of a fact, truth-based channel. So we're honest about the weaknesses of a case, even if we tend to believe, as we do, I think, in this case, that the defense has a great shot and that this whole prosecution is misguided. That's not our bent for every case. We may be the total opposite if the facts support being the total opposite. That's just what we do. So you can't ignore, because everybody seems to be aligned with Lindsay Clancy must be set free. Just because a lot of the folks watching are aligned that way doesn't mean we're going to ignore some of the weaknesses in that defense. And one of the weaknesses is you got to believe that she heard that voice and that led her to act as she did. You got to believe that if you're on the jury, because if you don't believe that, then how do you believe she had a mental disease or defect? Because then if you don't believe she actually said that or said it truthfully, then you think she's a liar, and you're certainly going to hold everything else against her as well. So that's an issue. It's an issue. But the only ultimate opinion before this jury at this point is that disease defect caused what she did on January 24th, 2023, when she killed Corey and Dawson and Callan. Now, that little hiccup there just before we broke, which was an interesting Reddington. I don't know if he ever thought he'd get this out, but he tried. The hypothetical he was giving to Dr. Zeisel, which was, hey, let's assume that the prosecution waited 3 years before they brought in 3 medical experts. Objection. Those are going to be the rebuttal witnesses. Okay. And it's not necessarily a big, gotcha moment to point out that they didn't bring them in until later in the process. The fact is, most of the time, the rebuttal witnesses are, as appropriate, responding to the defense case. So sometimes you may have an idea of what you need, but you may have some changes to it or have very specific needs that you didn't know about until they put on their case. That doesn't bother me a whole lot. But obviously what Reddington is trying to tell this jury is, look at these guys. They're sandbagging. They're waiting, and then they're going to bring on these 3 high-powered doctors who are going to draw, shit all over the defense case. I mean, that's part of the game. Sorry, it just is. That's why it's so important that the jury, see what feels right to them, because that's that's all that matters. Are they going to believe Dr. Zeisel? We hear battle of the experts all the time. I get it. In this case, there's kind of a voluminous amount of information that's being sifted and sorted through these experts, but it still comes down to, do you believe Dr. Zeisel that she was in fact outside of her mental capabilities, that she was suffering from a mental disease or defect, mental disease or defect, mental disease or defect. Those are the magic words. And if you believe that, then you're likely to go with not guilty by lack of capacity. Okay, that's what gets you in Massachusetts to lack of capacity to commit the crime. So interesting the way these things unfold, and we are getting to quite the crescendo in this case, I believe. We're going to hear more medical testimony. In fact, I would be surprised if we hear anything but medical testimony from this point forward, from either the defense or the prosecution. So that was the balance of the direct. This is what I really think, that had he had his druthers, that Kevin Reddington wanted to finish that yesterday afternoon. Just leave that, percolating in the minds of the jurors overnight. Mental disease or defect, inability to understand what she was doing, therefore not guilty. Boom. But he had to drag that out because there were some issues yesterday. It slowed down the process. So he got it in. Then we get to the bow. And here, I'm changing my opinion about who's really first chair and second chair. Technically, it is Miss Sprague. But I don't know that there's a more important witness to attack, to go after, than Dr. Z. And they've left that to Bo Buckingham. So I don't know. Maybe they're evil twins. They really are. People talk about it, but they're interchangeable somehow. I really would have expected Sprague to handle that cross-examination because it is so important. But nope, you got what you got. Okay, so let's look at some of the details. Some of my notes here. He was wrong about his work. She's trying to attack. Hey, well, you work basically for the government, or I should say, you work basically for defense and very little for the government, right? In fact, it's been, and she started to lay out how many years it had been since he had done that. He said, well, no, actually, I worked on this case and submitted a report July of this year. That's last month. She obviously knew nothing about it because it wasn't part of a lawsuit or a reported criminal matter. But I'm sure he's consulting on cases all the time that never go to litigation, never go in court, but are resolved by many of the other options you have. So she didn't know about that, made her look stupid, and she just went, okay, and she just moved on. If you don't have the goods for the gotcha moment, don't try, because if it doesn't work, you look like you gotcha'd yourself. Talked about the level of visits and time spent with Lindsay Clancy, making it sound like, well, that's bizarre, and you're doing that because you're buddies with defense counsel. And he was the thing about an expert that you want is admit when they've either made a mistake, and we'll go through a couple that he admits he made yesterday, and be willing to agree with somebody who is cross-examining you. Because if you, as my mom used to say, if you get your neck bowed, and you're just constantly denying anything they say, to the point where if they said, boy, the sun came up this morning about 6 o'clock. No, it did not. I mean, you look like a fool. So Dr. Zeisel does two things. He'll acknowledge when he's done something wrong, and he'll correct it and explain why he may have gotten it wrong. And if you present something to him that he agrees with, even if it may not be 100% favorable to the person you're testifying for, Lindsay Clancy, you still you say, yeah, you're right. That is not a gotcha moment. That is a real moment where the jury gets to see somebody, if they like them, that is, admitting maybe it didn't go as well as they would have liked. Here's how I would have done it differently. Here's how I made a mistake, and here's how I'm fixing it. She talked about the message from Lindsay Clancy to Paul. This was during that initial, that visit back on the 4th of February. This was as quickly as anybody could get in to see Lindsay Clancy, and the call expressing love for him, but not asking about the children. We know that's a common theme. And I don't know how the jury will play with that, to be honest with you. Does she not talk about the kids at all in any of the conversations we've been made aware of because she feels guilty about what happened? Certainly, that's going to be true. Because she's trying to hide something, or is it because she literally doesn't feel anything? I don't think people are going to figure she's this, uncaring soul, this heartless person. I think she is so guilt-ridden over what happened, she's not going to be celebrating it by talking about it or talking about them after the fact. And that's why a lot of these meetings, which we'll go into in some reference here to the 7,001 pages, right, from Tewksbury, Dr. Zeisel played that perfectly, where she was itemizing all of these visits. And of course, they were chosen because that was Cora's birthday, that was Dawson's birthday, that was Callan's birthday, that was the anniversary of the events, right? But I don't know what she gets with that. Were you impressed with that? Was there something in there that made you think, yeah, the doctor didn't look at those records because they didn't support his confirmation bias, or it shows how unfeeling she is because the notes from the android medical staff, and I'm sorry, but in those institutions, you're not getting quality time. They need to do certain things, observations, make notes, and it's very rote. So I don't make much of the note taking. If they had said something very special, like, Lindsay Clancy today said, she never liked her kids. I mean, something of substance, something that would stand out, something that would give the jury a little meat, that referenced guilt or psychosis or anything. But I don't give a rip if she's watching TV, playing dominoes, meeting with her parents were there a lot. It seems like almost every time they reference one of these get-togethers, that her parents were there. And now, were they there because it was these anniversaries that the prosecution was highlighting, or were they there a lot and they just happened to also be there on these days that the prosecution was highlighting? I don't know. I was interested, though, about the self-propelling of the wheelchair, because I've asked before, as I see her come into the courtroom every day and go out during breaks, she's never self-propelled, never. And I didn't know if that was because she didn't have the strength. There's a real question about her. She's paralyzed from the sternum down based on the fall, which we now know from Dr. La Posada, and it will not be contradicted, I'll bet you that she did a fall out the window. Not like a swan dive, not propelled, but more like I'll call it what I think in the stunts they call it a dead man's fall. You just kind of pivot over, boom, and go. Have you seen the idiots online that are trying to suggest that could never happen, and they're hanging out their windows? And what is wrong with people? So we know now from Dr. La Posada how that happened, and I was always very interested in the mechanics of that, not just because how it relates to her mindset, what was going on, but just the physics of how do you get those injuries, and what kind of fall leads to those injuries. So that was very helpful. And again, I don't think it's going to be contradicted at all. And the attack on Dr. La Posada was a big fail on behalf of the Commonwealth. So I was curious. So does she not have the strength to do it? Well, clearly she does. So I think it's more a custody and control issue with the court. They don't want her to have that. So I don't think it's a sympathetic thing like, hey, don't self-propel yourself. Don't let the jury see that you can actually do that. I think it's because she would then have, we're not going to see a wheelchair escape. But I think it's because the custody and control issues, that's why the bailiff brings her in, not one of the attendants. She is not allowed to do that. Back behind the wall there, I don't know, maybe she is propelling herself down the hallway to wherever they have their little meeting area. But it was interesting, I thought, because it answered the question about whether she could or not. Well, she can, and good for her. Little things can make a difference in your life, That for her is a major piece of freedom that I wasn't sure she had. Of course, I guess then, if that were true, she would have one of the, like a Stephen Hawking kind of motorized unit, right? So the fact that she doesn't, I guess maybe I'm not bright enough to pick up on that. But the fact she doesn't have one of those units leads you to believe nobody's going to be pushing her around all day, every day. She'd have to handle that herself one way or the other. So anyway, good to have some information about that. Yeah, let's talk about, I'm going to pull one of these up maybe for lunchtime. I was looking for the Beachbody commercial, and everybody has seen them, the infomercial. They're so just nauseating. What the hell is she thinking she's going to get out of this, going down the whole Beachbody thing, So Dr. Zeisel thinks it's a scam, and he's repeating what Lindsay Clancy had told him. And it all relates to her physical activity, that she's, depending on whether you believe diagnosis of mania or whether you just think she's an exercise freak. I don't know, but that's what it all related to. Whether she was, duped into this beach body thing. And the only reason, and I'm digging, to find any of that relevant at all is in the context of what the patient tells a healthcare provider as a lie or the truth. If she's lying about the whole beach body thing and being scammed, then what else is she lying about to the healthcare provider? That's the only thing I could get at from that. But I just thought it was amusing, and it made me think of those commercials, which are great. So I'm going to try and find one of those. Yes, we'll get a strike, as we do. We got another one the other day. I think for our show last night, which we had Dr. Joseph Witt Deering. If you haven't seen that, he was on again last night. We wanted him back on to kind of reflect on where we are now with the different testimony. Yeah, we got a strike because we're talking about offing oneself. So, we have to do the appeal and go through that. On the other hand, the AP feed, which we did a few days ago and got a strike for that, we appealed and we were vindicated on that. So, these guys got to fix the algorithm, especially when it comes to true crime. And I've mentioned it many times. It's just got to fix it. Otherwise, your bots are going to be very busy, both striking things and then the human review, if you believe that, reverses everything. And it's a whole process. I know it's all automated, but you're bogging down the system if you don't fix it right from the start. Drugs. Anyway, I called it the beach body rabbit hole when she went down that. And of course, I'm trying not to be mean and cruel. And I know in our chat, there's some mean and the cruel in there about, body shaming. It is ironic and amusing to see the Commonwealth as represented, talking about beach body and exercise videos, and talk about not knowing your subject. Anyway, talked about the time he spent, how it wasn't normal. He spent 35 plus hours with her. I think he then later said on redirect it was 60-ish, but it was a lot. And he admitted not typical, but not impossible, not that unusual, just not typical. And I kept pointing out to myself, I said, self, everything that I heard about voices, and the fact that she didn't tell any other healthcare providers about this hearing a voice, it's going to come down to this. Here's the jury weighing, did she actually say those things because she did hear a voice and because she was compelled by that voice? Was she saying it to create a cover story for what she did, right? Or was she afraid to say anything because of the prospect of losing her kids or being looked at as a lunatic and whatever fallout might come from that? So the jury's really got, it's even more than one or the other. It's not a dilemma per se. It's a quandary. See, a dilemma is two different things. A quandary is more than two things. They're going to have to me, that's the core of belief on the defense side. You have to believe the voice issue because it is so directly connected to psychosis. What is it Dr. Rizal said yesterday? 80% of psychosis cases involve hallucinations, audio hallucinations. That's pretty important stuff. Oh, speaking of important, me and words. I don't claim to be a perfect speaker of this language we have here, but there are certain words that drive me crazy. One of them, not in this case, but in general, how do you pronounce Nuclear? I think I spelled it right. Okay, you keep this in mind. It's like two words: new and clear. Nuclear. How many people say nuclear? It drives me crazy. And I will hear experts in the field say nuclear, and I immediately dismiss anything they have to say after that because you can't even pronounce the word right. Important. How do you pronounce that word? Important. It's important, okay? Maybe you don't punch the T as hard, maybe say important, but you don't say important. Like it's spelled IMPORN, important. Miss Buck, Bowtie Buckingham, she says important, and I don't like important. You put some fricative in there for me, For God's sake. Okay. Oh, then here's was a big gotcha moment. You ready for this? When she was in nursing school, she had anxiety, public speaking issues, and so she took some meds then. He talked about it yesterday. He identified 2 meds that she took. She actually took 3. Just forget everything Dr. Z told you, because he made a mistake. I missed one of them. And again, the way he admits it and moves on is the way the expert should be doing it. There are many things that make a good expert, and one is not pretending to be you're 100% correct about everything, because you're not. Oh, and I do like the part where he's talking about all these different attempts yesterday on direct, and again, the cross is punching at each of these things, points that he's been making. She went here and got no help. She went here and got no help. She went here and got no help. And so when attacked on each of those, saying, well, no, it wasn't, isn't that true? She went to one of the hospitals. I get them all confused here, but on December 15, she decided she didn't want a bed in that spot. Hold on. Something unimportant is coming in. Okay. And so it wasn't that she got no help. It was that she decided not to go into that facility, and she went somewhere for what I call mental daycare. You know, they call it partial hospitalization. So his response was, well, if she tells me I didn't get any help, it's not my job to ferret out what she felt was not getting no help. If she felt she got no help, that's all I need to know. I'm taking her at her word because I'm trying to help her. The fact that she may have been offered a bed, but still in her mind, that was no help under the circumstances. That's all that matters. And I think he diffused that pretty nicely. Came up with the diagnosis being bipolar disorder with psychotic, I think it was psychotic affect, but anyway, psychotic overtones. And remember, the bipolar issue was so scantily touched upon during all of these other healthcare providers' treatment periods that many think that's where everything went askew. Because as you know, when you're on your way from the diagnosis to well, and you're flip-flying all over the place, and nobody really hits on what may have been a core issue, which was bipolar, and that affects which meds you should or shouldn't take as well, you're doomed. You know, you're never going to get it quite right. Yes, did you know there were 7,001 pages from the Tewksbury records? Yeah. Let's go through each and every one of them, shall we? Page number 1. Okay, so she starts rattling off these dates, and we can see where we're going. You know, the dates are all the same. It's December 24th. That's Cora's birthday. It is January 24th. That's the date of the incident. It's May 26th. That's Callan's birthday. And it is September 30th. That's Dawson's birthday. Each of these days from the Tewksbury record, she did crazy things like ate dinner, parents visited, watched TV, played dominoes, talked on phone, no SIB, which was probably the only important information we got from all of that. And that is self-inflicted, what is it? Self-inflicted behavior. So self-injurious behavior, sorry. So yeah, that's good. That's good. But what's the point? Are you trying to tell this jury that on these very important dates, she was no different than any other day? It was just another day in the chair for her, and she did whatever they allowed her to do, or what options she had, and she had parents that would visit her. I don't know what the ultimate point of that reference is. And the fact that Dr. Zeisel didn't know it, I don't know, in and of itself doesn't do much for me. Did you think he's going to read the 7,000 pages and have specific comments on each and every question or each and every page? I didn't think so. So I'm not sure where she thought she was going. I don't know. I wish today I could have seen the jury to see if they were making notes, you know, the date, who was there, what activities. And if they were, maybe I would put more stock in it, but I don't know. I'll check. I got a couple of folks obviously still in the courtroom. I may check with them in the afternoon to see if that period of testimony resonated with them at all. But yeah, doggone it. Parents visited. Yep. Self-propelled in the wheelchair. That, again, that was, I thought, interesting for the reasons I mentioned. I also thought this was an interesting, this is where I think there was maybe a little bit of, I don't know if it was explained or pursued thoroughly enough, but I think it was an issue. And that was where Bo Buckingham was quizzing the doctor about this dual role of treating physician.
All right.
Okay, we're back. Folks. I'm going to hang out for a second, see where we're going before I get back to lurking and working. I'm guessing the jury is coming in. I may be wrong. Hold on a sec. Wait. Can you see? Domino, where'd you go? Where are you? He never lays on the floor. Is him on the floor back there? He never lays on the floor. What is wrong with that dog? Let's all play What the Hell's Going On? Okay, so this could be, we do have another video witness coming on today. I think that's Dr. Reskin. Who's an older gentleman. Karen Goldberg says the dog is scared of Bo Peep. Karen? Hey, I was talking to Reddington yesterday, and Karen, I mentioned, I said, I heard that, I told him, hey, I heard Karen Goldberg held you hostage yesterday at the gas station for about a half an hour. He said, you believe she has 8 kids? That was the first thing that came to his mind. I said, no, nobody does. We're investigating that. Today we have no glasses. I noticed yesterday in the afternoon she went
Court
to
is
the
back in
glasses.
session. You may be seated.
For the purpose of the record, we return back to the trial of Commonwealth versus Lindsay, Clancy. All parties are present, including the defendant and including the 18 jurors.
All right, we'll return now to redirect counsel.
Thank you. So as it relates to the concept of confirmatory bias, sir, in your opinion, with your experience, does the period of time within which an expert is hired by one side or another to evaluate a person and give an opinion, in other words, if it's a compressed period of time as opposed to an expanded period of time, is that one indication of confirmatory bias?
Objection.
Overruled.
It depends on the examiner and the situation. It can be, but individuals who pay attention to that concern should maintain healthful boundaries and not have any confirmatory bias.
What does that mean?
It means stay in your lane.
That's better. Now, one of the things that the district attorney did is took the 7,001 pages of the records from Tewksbury Hospital and read excerpts from them to you. Is that correct?
Yes.
And Lindsay, after she was taken from South Shore Hospital to Brigham and Women's, then from Brigham and Women's to the rehab, Spalding Rehab, she ended up in Tewksbury. Is that correct?
Yes.
And Tewksbury's been very good. I mean, in your opinion, have they been good with her? And
Fantastic.
Fantastic. But nevertheless, that is still a facility that is a state facility, right?
Yes.
And the district attorney asked you about the plan to have Lindsay go to another facility, Worcester, I think it was.
Worcester Recovery Center Hospital.
Is that a relatively new facility?
It's, I believe, the newest facility in the Commonwealth.
And did we have Lindsay evaluated to have her transferred to Worcester Hospital?
Yes.
Was she allowed to make entry into Worcester facility?
She was not.
Why is that?
She was not allowed because she was not allowed because she has pending criminal charges.
That'd be this case here, right?
That's this case here.
And the district attorney took the 7,000 pages in one of the records and apparently went through them to the anniversary of the death of her 3 children, correct?
Yes,
Went through them to highlight each birthday of her 3 children, is that correct?
yes,
In your opinion, you've been in a lot of mental institutions and facilities in the Commonwealth and out of the state, correct?
yes.
Is it your understanding to a reasonable degree of medical certainty that the fact that a woman who is paralyzed is propelling herself down the hall from one room to another is indicative of anything?
Not at all.
How about the fact that her mother and father, who have been with her for 3 years and practically missed not one day of sitting with her and bringing her dinner or lunch, is that something that would be indicative of undercutting the fact that the woman was suffering from mental disease or defect?
That's indicative of love. And
How about the fact that she's talking to other inmates or people that are patients? And in your review of the records, would you tell us your opinion as to her level and degree of popularity, bluntly, in that particular ward?
she is extremely, extremely well regarded and well liked on that unit by everyone.
Overruled.
How about, in reviewing the records, I didn't hear that she's laughing and partying and having a good time while she's in the Tewksbury Hospital. Did you see anything like that?
No, Lindsay Clancy has bad days and worse days.
And when you speak with her and meet with her, doctor, has she ever mentioned her children? Because apparently, according to the questioning that you underwent, she never talks about her kids.
She does speak about her children.
What does she say?
She really loves them and misses them and thinks of them every single day, almost every moment of the day.
And finally, doctor, I'm holding up what has been marked as Exhibit 1 or I don't know, for identification. Have you seen this before?
Yes, I have.
And in your dealing with Lindsay and interview of collateral contacts such as Patrick, do you know what that is?
Yes, I do.
What is it?
It's called a wish vase.
And what does that mean and what is it?
This is a vase that Miss Clancy and her husband purchased in Hawaii when they went on their honeymoon shortly after getting married.
I was objecting.
Yeah, sure. See sidebar, please.
Your Honor, I would hand this to Chrissy to have it marked.
All right. Over the Commonwealth's objection, that may be admitted.
285.
Thank you very much.
All right. Commonwealth?
Very briefly, please. Doctor, how many defendants that you've evaluated for criminal responsibility have you spent 35 hours evaluating?
One
Is that
one other person.
And how many other defendants have you evaluated that you've testified that you care deeply for them?
I would say one other one.
And how many other defendants have you given press conferences about?
None.
And how many other defendants that you've evaluated have you gone back every day until the lockup to check on?
I was sequestered on all those other trials, so I was not even allowed in the court.
Now, you were asked about confirmation bias and given a hypothetical about so if somebody was asked to examine a gun, right? You recall that
Yes,
line
I
of
do.
questioning?
Yes.
You were hired by the defense in this case, were you not?
Yes.
And as far as your conversations with the defendant about her children, you're also aware that she continually refers to this situation as my tragedy, does she not?
That moniker of my tragedy, that's just one of the things that she'll say.
All right, thank you.
You're welcome.
And what's the reason that, with the understanding of the court permission, that you go to the lockup and see her during this trial?
I go to the lot.
Sustained.
Well, while she's in Tewksbury, counsel kept referring to SID, SI. What is SI?
SI is suicide intention or suicide ideation.
In Tewksbury, excuse me, in Tewksbury, has there been a concern of suicidal ideation?
Yes.
And what, as a result of that, SI, as counsel kept repeating to you through the records, is her status at Tewksbury?
She's on a constant one-to-one to ensure that Ms. Clancy doesn't take her own life.
And that is somewhat similar to the reference in Brigham and Women's Hospital when you were talking with her that there was a nurse that was sitting in the corner of the room at all times. Is that right?
Yes, that's correct.
Inferentially was able to hear any conversation that you had with Lindsay, right?
I asked those people to leave.
Thank you.
Counsel, could I see just one?
So finally, I will ask you again, what, to your understanding, is the purpose of you during this trial going back, as the counsel asked you about, to the lockup with Lindsay?
To ensure that Ms. Clancy is stable and competent to stand trial.
Any concerns as far as her SI?
She's in good hands at the moment, but there's always a concern that sits directly below the surface.
Thank you.
You're welcome.
Attorney Buckingham, please.
Dr. Zeisel, in 3 years, she's never made an attempt to harm herself, has she? Other than January 24th of 2023.
No.
Thank you.
All right. Anything further?
Questions, Judge? Thank you.
All right. Thank you, Doctor.
Thank you, Your Honor.
All right. Attorney Reddington?
It's up to Your Honor as to the voir dire on McLean Hospital witness or Dr. Spinelli. I know.
All right. Counsel, let me just see in regards to the timing on Members of the jury, this is another one of those moments I've got to talk to counsel about a matter that I've got to talk to them outside of your presence. All right, so I thought we'd do it at this point and excuse you till 2 o'clock. We'll take up the next witness. We're going to stay in here and we're going to take up that other matter. All right, and so with that, during the break, remember, same instructions. Don't talk about it. Don't do any research about it. Don't read anything. Don't go anywhere in regards to this. And I'll see everybody at 2 o'clock. Okay.
All rise, please. Your next seat.
Jurors have exited the courtroom. This court's in session. Please be seated.
All right. All right, counsel, we ready to do the voir dire of Ms. Thorndike?
Thank you. She should be right outside.
Remember, one that worked at McLean from 2015 to 2021, about a year before Clancy worked there. So is it relevant in that? We're going to focus on these staffing issues that we believe will be so important. This is there's Dr. Zeisel, very restful point of the day for him. Like, I'm done. This ought to be very interesting.
Do you solemnly swear that you shall make true answers to such questions that shall be put to you this matter now?
Hey, good afternoon.
Good afternoon.
All right. Attorney Reddington.
Thank you, Judge. Tell us your name, spell your last name for the record, please.
Emily Thorndike, Thorndike.
And what town do you live in?
I actually live in Brooklyn, New York, but I summer on Cape Cod. I'm spoiled like that, so I'm in
Okay.
Chatham.
So where do you live now?
Brooklyn,
But where you live? Are you
in Chatham.
Chatham?
Yes.
And what do you do for work?
I own my own therapy practice right now, so I'm practicing as a business owner and a therapist.
And what is the name of the business?
It's called Wise Mind Therapy Practice.
What is it?
Wise Mind.
Wise Mind?
Yeah.
Okay. And where is that located?
It's a virtual practice, so yeah.
And how long have you been doing that?
So I had my own private practice I opened that January 2023, and then this past May I expanded. I hired somebody, so technically it's a group practice, but I've owned my own business technically for, 4 years?
So tell us your educational background, please.
I went to Dover-Sherburne High School, and I went to Hartwick College, and then I went to Boston College School of Social Work.
And what degrees do you have?
So I have my master's in social, well, I have my BA in sociology. I have my master's in social work, and then I have 2 social work licenses, I guess. You have to get one before the other. So I only go by a licensed independent clinical social worker. So, but you have to get it's very confusing. You have to get 2 licenses essentially.
You have those licenses?
Yes.
Within the Commonwealth of Massachusetts?
Yes.
Now, your employment, can you tell us what your employment history was since I guess you got your master's at BC or something?
Since I got my master's at BC, I did my final year internship at McLean Hospital at their trauma program. And then once I graduated, got my MSW, my master's of social work, and then my social work license, I was offered a per diem position at that program. And I did that position for, I think it was 2 to 3 months. And then I was rehired. I went back to the short-term unit at McLean, which I had previously worked at.
So when you say the short-term unit, is
Yes.
that also referred to as the STU?
Yes, we call it the STU. It's just short-term unit. It's also referred to as AB1, which is admissions building first floor.
Now, are you familiar with this case of Lindsay Clancy?
I'm only familiar about it from what I watched before I was sequestered, but other than that, I don't know the case at all.
And when you say what you watched before you were sequestered, what
Yes.
does that mean? What did you watch?
I think it was not this past Thursday, but the one before that. I'm not going to recall the date off the top of my head, but that's when, you had told me that I'm sequestered and to no longer watch the trial or consume any of it.
So what were you watching?
I had just been watching like the day to day, like the live stream and just, yeah.
Why is that?
I'm interested in the case. I honestly got into sort of watching trials from the Karen Reed trial, and then I wanted to watch this case. And obviously, I worked at McLean, so I was curious to watch it.
And when did you work at McLean?
I started there in 2014, and then I left there in December 2021.
So how many years is that?
Oh, 7 years, 8 months, I think.
And what was the nature of your work? What'd you do?
I started as a mental health specialist there, which I think you can sort of try to summarize as those are the counselors are sort of directly on the unit with the patients. Our main role is to keep patients safe, really. So you're doing a lot of safety checks. You are putting eyes on patients to make sure they're not trying to harm or kill themselves. And we do crisis intervention. So when those things are happening, because they do, we are the ones to intervene. And unfortunately, there are a lot of restraints that happen on those units, and that's one of our main jobs.
So the STU that you refer to, are there a couple of them at McLean? Or?
So I'll try to explain it. When I first started there in 2014, it was one unit with 28 beds. During the time I was there was a renovation. They expanded the unit. It's a little confusing, but in 2016, I believe it became two separate units operating the same way. So there's short-term unit north and then there's short-term unit south. And now south has 22 beds and north has 23. So that's why you'll see like, AB1S or, so they're the same unit, but there's a south side and a north side, if that makes sense.
When you were working in that particular unit, is that the same unit that Lindsay Clancy was in for the 4 to 5 day period?
Yes, I worked on both north and south for a significant amount of time.
And for all those years that you worked there, did you work days, nights, weekends, holidays?
So days and evenings, I preferred the evening shift, but you're supposed to do both, day and evening. I didn't do night. Sometimes you get mandated and you have to work an evening and a night shift, which is always pretty brutal, but I was day and evening.
Now, how about the staffing at STU, your experience?
So there's always I can sort of start with the week, I guess. There's always 4 mental health specialists and 4 nurses during the week for the day shift. And then in the evening, it's 4 mental health specialists and 3 nurses. And then there's 1.5. It's hard to explain. There's at night, there's 3 mental health specialists, and then there's 1 nurse on north and 1 nurse on south, and then there's a nurse that goes in between at night to help both sides.
And how many beds are in the north and the south?
North is 23, south is 22.
And which one was Lindsay in?
South.
Are you familiar with the Code of Mass Regulations or regulations that mandate or require certain staffing levels within that particular unit, the STU of McLean?
Yes, like the Department of Mental Health regulations.
Can you tell the judge what your understanding of the regulations from the DMH would be on staffing?
Yeah, so the Department of Mental Health has to oversee all of the mental health facilities in Massachusetts, and they have specific requirements for safety regulation, for staffing ratios, how the unit has to be set up. For example, there was a renovation while I was there to adjust handles on a sink because you could use it to harm yourself. So DMH, there's usually an annual or biannual inspection, and they will go around and they will look at charts, they will look at the unit, so they oversee everything.
And they mandate how many doctors or nurses or safety people would be on a particular unit?
Yeah, they definitely have those requirements.
And what's your understanding of those requirements?
I believe, I don't want to, I'm not sure exactly. Like, I know McLean follows those regulations, but I guess there's, potential that, McLean might go higher than the ratio. I'm not sure. So you have to at minimum have a certain amount of staff, but I'm not exactly sure on that.
So are you aware in this case that McLean forwarded to the district attorney's office and the court certain discovery
Yes.
indicating how many doctors, nurses, and
Yes.
safety workers? Did you have a chance to read that?
I did.
All right. Is it your understanding that the requirements of the DMH and minimum staffing on, well, let's say on weekends and holidays, for example, does that change year to year, or is that pretty static?
It's never changed. I mean, it didn't change from when I was there and with that document. So I guess that goes to what, 2023 it was. So it didn't, that was how it was when I started. Well, I guess one caveat, when it changed from a 28 bed unit to 22 and 23, there was, different numbers, because with 28 patients, you have to have, a certain number of staff. But so since it's been 22 and 23 patients on those two units, the staffing has not changed from when I started there and from that document that I reviewed.
Now, you indicated that you, because of your interest, were watching the proceedings on this case.
Yes.
On what, YouTube or something? Or
Yeah, whatever.
TV?
You can, yeah.
And you had the occasion to hear the cross-examination of Patrick Clancy by the district attorney, is that
Yes.
right?
You mean the direct,
I'm sorry?
the direct of
Sorry,
Patrick Clancy.
you're right. It's been a long week. Okay, direct examination. And the focus was on the fact that when Lindsay went into the hospital, it was on New Year's Eve. Is that correct?
Right. Mhm.
And that she was there for that holiday weekend, and I
Right.
think the following Monday was a holiday?
Yes.
Okay. And you heard the direct examination of the district attorney asking about McLean being number one hospital in the country, McLean having all of these services available to the inmates that are in there, treating them, offering all these fantastic programs on the holiday weekends and the holidays, as opposed to what Patrick had testified to. Did you see that?
We re-asked that question. I think I understand, but
Okay, when you were watching on the television,
yeah.
you saw, or the computer, you saw the questioning of the district attorney of
Right.
Patrick Clancy.
Yep.
You heard Patrick Clancy make reference to the fact that his wife admitted herself into the
Right.
STU
Yep.
on the holiday weekend, New Year's.
Yes. Yes.
Was there all that weekend
Right.
into a holiday.
Right.
And the district attorney then questioning Patrick
Right.
inquired as to whether he was aware that it was
Yes.
the best hospital in the country, that there were many doctors and nurses and staff available and programs available, and Lindsay wasn't interested in any of that, right?
Yes. That's what I took from it.
Now, in your 8 years, however many years of experience that you had, is that what your understanding was in that unit?
No, no, that's not what I was understanding. No.
So tell the judge what your understanding was from your experience, hands-on, day after day, working in the STU for all of those years.
Right.
But you also were a supervisor of the STU at one time.
I actually wasn't. I became a social worker there. So I guess you could, one way to look at it is that, the social worker and the psychiatrist, you are the treatment team. So you're making all the decisions for the patients. And so the nurses and the mental health specialists, I don't like to create a hierarchy, but they are operating underneath you. So in a way I'm supervising, but I was never a direct supervisor.
Now, you came out with a TikTok or
I did.
a reel or whatever you call it.
Yeah.
right?
TikTok.
And would you agree with me that you were pretty angry when you did that?
Yeah, definitely emotional.
So tell the judge, why were you emotional when you did that TikTok?
Well, it's a lengthy TikTok. It's about 10 minutes. And, I was emotional because I felt like, what was discussed, in court was not aligned with what my experience was. I noted several things. I'll try to summarize some of them. There was mention that there's individual therapy on the unit. There is not. There was mention of seeing a doctor every day. I felt like there was some misleading of that. You do see a doctor every day, but on the weekends and on a holiday, it's one doctor who's seeing all of the patients. The meetings can be as short as 1 minute. Many patients decline those meetings. And the doctor who's there on the weekend and holidays is seeing 23 patients. So I felt it was misleading to indicate that there's sort of a in-depth doctor session when it's very brief.
How about programs that are offered, like making things out of clay and crayons and stuff like that?
Yes, there's clay on the unit. It's called Model Magic. It's a non-toxic kid. It's it's advertised for kids, but it's on the unit. It's in the nursing station. It's out on the unit. There is a lot of coloring. There's a specific group that I saw in the documents I reviewed called Music and Mandalas. Mandalas are basically adult coloring books. The designs are kind of abstract. You could compare it to like looking through a kaleidoscope or something, and you color them in. And Music and Mandalas is a group where you play music and the patients color.
So you understand from watching the proceedings that you became emotional over is that Lindsay went in on New Year's Eve with some fairly serious
Right.
symptomology. Is that correct?
Yes.
And Patrick indicated that they were, quite frankly, pretty bluntly disgusted with the help and the care that was allegedly offered to her, right?
Right.
And you were upset about what you felt was a misleading of this witness based on the questions that were asked. Is that right?
Yes.
And Patrick had made reference to the fact that she was doing coloring and she was in the groups that were sitting there dealing with the clay, and that they felt that it was not, bluntly, any help.
Yes, and there's very minimal like family contact when the main treatment team is not there, so it's not abnormal that families wouldn't be getting like regular or like in-depth updates of what's going on. You're sort of supposed to wait until the treatment team comes back, whether it's on a Monday or in this case a Tuesday, since Monday was a holiday. That's the team who's going to be working with the patient. So most updates and communication with family and with providers aren't going to happen over the weekend either.
Now, one of the things that occurred, just for the background, is that your TikTok was observed by me, and I tried to reach out to you and
Yes.
couldn't find you.
That's correct.
And then I had a private investigator, Bob Jones,
Yes.
hunt you down, kind of, and ended up in front of your house.
No, Bob and I were sort of chuckling about that because he never ended up outside of my house, but the rest of it is all accurate. So he wasn't outside of my house, but the rest of that was true.
So he was able to locate you.
He was,
He was
yes.
able to talk to you,
He was, yes.
get your contact information.
Yes.
Provide that to me.
Yep.
And as a result of that, I reached out to you, and then you indicated that you initially somewhat reluctant, but then ultimately agreed to get involved and talk to the judge, right?
Yes, yes.
Okay. Now, the district attorney is objecting to your testimony, and I believe they're going to argue that the change from that 1 year period, when did you leave working there?
I want to say my last date was like December 18th. I since working there, you don't get a lot of holidays off. So out of all my time there, I said, I'm going to leave right before the holidays and be able to enjoy that. So I believe it was December 18th, but mid-December, 2021.
2021.
Yeah.
And when was Lindsay in there?
December 31st, right? She came in on New Year's Eve, what would that be? 2022, right? Yeah.
2.
Yeah.
So in your opinion, is there a change that is
Right.
significant in the staffing, in the nurse to patient ratio, in the safety issues, the crayons, the coloring, and all of that? Is there any change from that 1 year that you left to the time that she was in there?
From the records I reviewed as well, those are exactly the same staffing ratios, and all of the groups are the same.
So there's no change whatsoever.
Not from what I can tell from what I reviewed.
Thank you.
hmm
All right, Kamal?
Good afternoon.
Hello.
So You are currently a social worker who does their own, a licensed independent clinical social worker, right? That's the license.
Title,
So when
yeah.
you're saying
Yes.
that's really what you kind of go by.
Yes, I'm a social worker by trade, you could say, but I'm practicing as a therapist.
And you do that virtually?
Yes.
So you don't have a brick and mortar where clients come and engage in therapy with you, right?
No, rent is expensive, so right now I'm all virtual.
And you indicated that in your time at McLean Hospital that you first started as a per diem, and that was as a mental health specialist, right?
I didn't start per diem there. I started at a 32-hour position. The per diem, there's another position I held at McLean, which is called a community residence counselor. That was a per diem position. And then the social work position I took after graduating and before I went back to McLean, the short-term unit, that was a per diem position.
So the per diem role that you had, how long did you do that role?
On which unit?
Well, you just said,
Right.
when I asked you about working per diem, you said you were the community resident counselor.
Yes, I mentioned two per diem positions, so I just wanted to be clear. I believe it was around a year. It was on the side while I was working on the short-term unit. That was the main unit I worked on. But since I was 32 hours, I was interested in that particular McLean program. So I picked up a shift, every so often. But I was primarily on the short-term unit.
As what, though? As a mental
health specialist, yep.
And so you said once you got your master's, you took on a role of clinical social worker there, right?
So yes, I did.
And that was in September of 2019?
Yes.
And you said you had a chance to review the records that were sent over by McLean, right?
Right.
Now, when you were a social worker from September of 2019 to December of 2021,
Yeah.
what was your schedule?
So I would come in around 9. You could view it as sort of normal business hours. My clinical rounds that I did with all the multidisciplinary staff was at 9:55. So that was kind of a little bit of my start time, but generally probably like 9 to 5, you could say.
And was that Monday through Friday?
Yes, I did cover weekends on occasion. Social workers, you're not required to, but it's kind of highly encouraged. So, every once in a while, I would cover a weekend as a social worker.
And you're aware that the records that came from McLean Hospital indicate that during the time period of January 1st to January 15th of 2023, that the social worker role was a day position that was Monday through Friday.
Yeah.
And that on January 1st, which was a Sunday, there was no social worker there.
Yeah, I saw that.
And on January 2nd, which would have been the observed holiday for
Right.
New Year's, there was no social worker there.
That's what I saw.
Okay. And while you would pick up shifts, the majority of your schedule was 9 to 5, Monday through Friday.
Yeah.
From 2019 to 2021.
Yeah, I did regularly pick up weekends, but yes, primarily I was there during the week.
Okay. Now, you provided Attorney Reddington with some kind of typed up notes. Do you recall that?
Yes.
Where you outlined kind of what your experience was on the unit and how inpatients were, how inpatient experiences went, the schedule and that kind of thing. And you noted that as far as the treatment team, which you referred to yourself as a social worker, worked with a psychiatrist, right?
Right.
And you identified that in your experience, there was 3 teams, red, green, or blue.
Yes.
But you are also aware that the records show that every day during the week, that the treatment team of a social worker and a psychiatrist, there was 4 social workers and 4 psychiatrists that were on shift.
Right.
So where's the 4th?
So the numbers aren't equal. So the medical director often took residents. So he would have a little bit less of a caseload. The lead social worker on the unit, she would go in between the different units. So she would take a smaller caseload on one unit. So for example, I had 8 patients on my caseload, but one of my social work colleagues would have 6. So it's not an even distribution of the 3. Some of the doctors and some of the social workers just carried a different number of caseload. So
But your testimony today, after having now reviewed the records, is that it's always been for social workers, for doctors.
Yeah, I didn't say that there wasn't before.
Well, that's why you're here, because we don't know.
Yeah, I
what
just
you said
thought I
before.
answered your question. So, but yes.
And you came aware of this case by watching the trial, right?
Yes.
And so would you say that how many days of the trial did you watch?
All of them up until that point.
At what point? What day?
I'm not remembering the date exactly. Not last Thursday, but the Thursday before.
What was the last content of testimony that you remember watching?
I believe it was maybe Patrick's friends, or I was aware that there were doctors testifying. Mr. Reddington made sure I was not watching anymore, and that there were doctors coming up that were particularly important for me to not watch.
And you were asked by Attorney Reddington here about observing that testimony or the direct examination of Patrick. And I think he mentioned where it was referred to that McLean was the best hospital in the country. Do you recall that being the question that was asked of Patrick Clancy?
I don't recall.
And in fact, the Commonwealth didn't ask about his opinions of the status of the hospital, but did just verify with reference to records whether or not he knew his wife participated in particular things that were contained within the records. Did you see that in the testimony?
Yes.
And so you're aware that the testimony actually was that, or the question was, were you aware that she declined groups?
Yes.
And that's based on records you've never seen, right?
Correct.
And as far as the contact with the staff and the doctors, meaning nurses or social workers or whatnot, you haven't reviewed any of those records, right?
I have not.
And so you don't know the extent of what the interaction was with the nurse and the patient, do you?
I mean, there are some general guidelines that you have to follow. I can't tell you the content within them, but for example, mental health specialists, you're not supposed to meet with a patient longer than 20 minutes because you have other things to do. So I can't speak specifically to what happened in those conversations, but I know the general gist of how everybody's role works.
But you, when you say everybody's role, did you ever perform the role of a nurse?
No, but I work directly with them. I'm operating on the job description. It says specifically you're under the direction of the nurse. So I worked directly with nurses.
Do you go through the same training as a nurse?
No.
As far as what your knowledge is of mental health specialists, fair to say the last time you were employed as a mental health specialist there and did that work yourself was in May of 2019.
Yep.
And then you transitioned to being a social worker where you worked closely with the psychiatrist and primarily Monday through Friday.
Yeah, psychiatrists, the nurses, and the mental health specialists, you all really work together.
And you can only attest to what you would put in a note, right? As far as your contact with a patient as a social worker?
No, you have access to all of the patients on the unit. So I'm able, and it's not a HIPAA violation to do that because we all work together. Sometimes I cover other social workers' patients. So I do have access. You have access to all of the records in every patient's file. So you can read everybody's notes.
I guess my question, and that probably was a bad question, but my question is to you. When you are the social worker for a patient on the treatment team that you've described,
Yep.
you enter the information into the note for the social worker that becomes part of the record.
Correct.
And those are your words, your observations, your contact.
Correct.
You don't write them for other people, do you?
No, but we have to follow a certain format. So for example, we have to write a biopsychosocial note, which is a fairly lengthy assessment, but that's a social work. I learned that in grad school, so I don't know how everybody writes their notes, but we have to follow a pretty strict format to write our notes.
And is it your testimony that McLean requires only the that each social worker spends a particular period of time or a max amount of time with each patient to do that?
Yeah, I mean, I have 8 patients on my caseload, so I have to see 8 patients every day. And so you are limited with how much time you can spend with them because there's several other tasks I have to do. So you really can't spend a significant amount of time with your patients.
That wasn't my question. My question was, does McLean tell you that you can only spend 5, 10, or 15 minutes with a patient?
Yes, it's directly told from the people above me. It's something that's communicated in a way where you could sort of get in trouble if you're not doing that. So yes, it comes directly from McLean.
And do you have any information, having left there in 2021, that the same people supervising the social workers were giving those same instructions?
I mean, no, I don't know that.
Do you know anything about how many people were actually occupying beds between January 1st and January 5th of 2023?
No, it obviously has a max of, but so I don't know how many patients were there, but you can have up to 22 there. So yeah.
And you've also indicated in your notes to Attorney Reddington that sometimes the people that are there for a particular period of time have the ability to go out on passes for weekends.
Correct. Yes.
Does that, in your experience, did that tend to happen around holidays?
Yes.
And so you don't know between January 1st and January 5th of 2023 who might have been assigned to a bed there but out on a pass that weekend, do you?
No, I don't know what happened that weekend.
And that would affect how many people are actually occupying the beds, would affect the ratio of staff to patient during that time period, right?
If I'm understanding the question correctly, I mean, it's the same amount of staff there. Are you saying like they
right? It's the same amount of staff, regardless, because it's by shift, right?
Right.
So if the unit has 22 beds in it, but say 5 people are off on a pass for that weekend, then the same staff that are there for the entire weekend have 5 less patients.
No. You're still assigned. Every patient has to be assigned to a mental health specialist and a nurse. And so when you go on a pass, there's a limit. And day and evening shift, like the limit of the pass is 8 hours. So no matter what, you have to check in with your staff person before you leave for your pass, and you have to check in with your assigned staff when you come back. So there's no patient who's not assigned to somebody. It's just they might not be on the unit the whole time when you're on your shift.
Okay, so if they're not, they might not lose a patient on their load, for instance, but that person isn't there that they have to check in with every so often, or they have to check in with about groups or keep track of or meet with, right? If they're on a pass and they're out of the facility for 8 hours, they're physically not present, and that worker doesn't have eyes on them.
Yeah, you only check in once per shift anyway. So if they're going, you check in with them before, and when they come back, you check in with them after. But yes, you're not checking in with them when they're off the unit.
And you don't know what the numbers were?
No, I don't.
During that time period? I don't have any other questions. Thank you.
All right. All right, Ms. Rankin, I'll hear you on the motion. You may step down. Thank you very much.
Thank you.
Your Honor, I think it's obvious that the witness has the educational background. She certainly has the experience, interestingly enough, of that very unit that Lindsay was on for that period of time. She's well aware of the staffing, indicated to you that the staffing ratio to patient, et cetera, has not changed according to the items that the government has brought here today. That at the time that she was there, it was on a weekend. She indicated about the the weekend staffing, the holiday staffing. Indicated that they have these coloring programs and programs that Patrick was relating to, and indicates this coloring crew, if you will, in a sense, on that particular period of time in the holidays, which is very corroborative of what Patrick had indicated in his testimony. So, you know, I'm not looking to bring her in to disparage McLean Hospital. They've done a good job of that themselves. I'm bringing her in to just have evidence as to what Patrick's testimony was relating to what his wife went through when she was in McLean, to corroborate the fact, as opposed to what was raised on direct exam with the government when they were questioning him about all of these wonderful programs that she apparently was not interested in participating in, which is very, very, I would argue, improper inference for the jury to consider.
All right. Kamal?
Your Honor, would object to the witness, and even now after the voir dire, I think it's clear that the best evidence of what the defendant was provided by way of care, treatment, however you want to call it, is the record in and of itself. It's the record from McLean that documents each and every contact she had with each and every person that was on staff during the time period she was there. Now, just to be clear, there's been some indication that she went there on the 31st of December, but the records are clear to say she was transported, and she didn't arrive at McLean until the early morning hours of January 1st. So that's when the records start, and they document her each and every day and each and every step of the way, consistent with how Dr. Goodhart described the process of how you're intake and then how you go through the day and what the general schedule is in the contact with the treatment team. This witness is offering no more information than what's contained within the record, and no more information that's what's contained in the records that were just received for the trial subpoena. And I would suggest to you that the fact that she, in her last role as a social worker from 2019 to 2021, where she was a day staff person that worked Monday through Friday, that wasn't there on the weekends, that she does have a limited amount of information, and it's attenuated, more attenuated than we had initially believed, from the dates in which the defendant was at this particular hospital. So I would suggest, or I would object and argue that the best evidence is the records in and of themselves, the records that now have been subpoenaed that can be admitted to identify the particular staff. I'd also like to point out that counsel is referring to offering this to rebut certain inferences or certain statements that the Commonwealth made in the direct examination of Mr. Clancy, but no one has said that McLean is a #1 hospital. That wasn't the testimony. That wasn't the question put before him. It was simply what he knew, what he observed, and if he knew what was contained within the record. So there's been no presentation of evidence that would suggest that a person needs to come in to dispute that the groups are the groups. The court and the jury can see from the record what the groups were, and they can make their own decisions based on what they described them to be in the record, if that was treatment or not treatment. I don't believe that the Commonwealth presented it as treatment. I believe the Commonwealth presented it as resources available to the individual while they were there at the hospital. The treatment piece or the therapy comes from the psychiatrist, which this witness can't testify to because she's not. So I would object for her to being called as a witness for those reasons.
All right. All right. Well, I'm looking at this really as a kind of two issues. First is late disclosure of the witness, and I'm not, and that goes into a whole different analysis, and also analysis under Rule 403, which is relating to relevant evidence. And as that rule, proposed rule says, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of, that part doesn't apply. First off, I find this witness credible. I find that, and I appreciate her being willing to offer the information that she has, but that's not always the whole finding on this. And so under cases such as Taylor versus Illinois, Commonwealth versus Dunning, Commonwealth versus Steinmeier, a couple other cases, I have to look at a number of factors. The first is prevention of surprise. Well, the Commonwealth has been aware of this issue for at least a week or so, so I'm not considering that. Evidence of bad faith, there's no bad faith I see from either side in naming this or calling this person at this time. There's the prejudice to the other party. I think there's just limited prejudice, if any, to the Commonwealth. However, though, the final two are the issues that I think are more relevant in this. One is the materiality of the testimony in this. And I find that there's limited materiality, that's hard to say, because mainly this witness hadn't worked there for a year. So there's at least a gap between when she worked there and when the relevant time period is here. There's also, I imagine, different personnel. They're working on different shifts. And so there's kind of limited value to that testimony. I also, I don't remember any five-star type inferences. In fact, so I'm not going to, that's going to be measured by the jury. But I didn't see any mentions that this was a five-star facility. And then also, the concern is, or the factor is, the effectiveness of less severe sanctions. And I would find that the records that have been brought in pursuant to the subpoena in the last couple of days from McLean's talks about the staffing levels on holidays and not on holidays. So if there's a question of whether or not there was a quote unquote skeleton crew that was on for those, at least the first 2 days of this time that Ms. Clancy was there, that's reflected in the records. There also in the records here is a list of whatever programs were offered and also when they were offered. So if there's a question of less programs being offered on a holiday than during the week, those are contained in the records. And so I'm going to deny the defendant's motion to call this witness, but I am going to allow the defendant, if the defendant wishes, to submit those McLean's records specifically regarding the staffing and the programs that are available, not just on that weekend, but for the week. And I think there's records in there for the week before. So there could be a comparison between what was available to Ms. Clancy during the week and what was available to her on a holiday weekend. So that's going to be my finding. I'll issue a written ruling on this, but I just kind of wanted to give the parties at least some idea, as well as the witness who's been here, I know, a couple of days. I just kind of wanted to thank her for that. So with that, we'll be in recess till 2:15. We'll come back and resume the trial. Okay?
Thank you.
Board, all rise.
I know it's a technicality, no my objection.
Duly noted. Thank you.
All right, so we called that. I felt that was the right answer even before I heard from her, and then when I heard from her, I really felt it was the right answer. She was kind of annoying, to be honest. Perfect pressured speech. If you're really unsure what that means, watch some of her testimony again. That I gotta get in there and answer. Can I finish the damn question? No, because I have pressured speech, so I will not let you finish anything before I jump in. So, and if you're the defense, do you want those records in? I'd have them put in. I wouldn't dwell on them. I wouldn't be focusing on it. Probably even in my closing. Might just tell the jury they're there if they feel like they want to check them out and see what staffing was really like. If you have some questions concerning what kind of treatment she received based on the testimony that has been allowed, take a look at the records. You can see how many people were working at a given time, and it wasn't quite the Sandals Resort experience that it may have been suggested. And it wasn't. The judge said, I didn't hear any that it was a 5-star facility. Yeah, well, it wasn't a 5-star witness either, so it makes perfect sense. So, TikTok to testimony, loser, down, not going to happen. And she was much better on TikTok, so maybe that should be a better forum for her. Welcome to the lunch break. If you have any questions, get them in. QQQ, question mark, question mark, question mark. Sometimes I just grab stuff because I think it looks interesting to talk about. So that means anything you put in chat, who knows, either by a slip of my finger or evil design, I may pull it up and we may talk about it. So I'm glad we got that done, though. At least that was one of the last questions, hanging in the air about the defense case, which, the way things are going now, I don't think it's going to finish today. It may slop into tomorrow morning. That would mean the rebuttal begins at some point tomorrow, And I mean, we may end up filling up that. I thought Friday might be kind of a wobble day, like we won't need it at all, especially for the jury, but great for the jury instruction conference, the verdict form conference. I don't know. There may still be some leftover rebuttal that goes on Friday. Depends on how the rest of the case moves forward. Because as you know, can you see if I can turn it around? Can you read that? Trial is a living, breathing thing. You just never know. And sometimes, speaking of barely living and breathing, Domino, Doofus. He is so dismissive. Okay, so anyway, where was I? Let's see if there are any follow-up notes before we get into your questions for the crazy idea that for the Q&A session, I'm going to actually look at questions. I know it's wild. Emily Thorndike the third. I don't know if she was the third or not. Yeah, I was not as impressed with her as I'd hoped. I do still want her on now that I've kind of muddied that. I still would love to have her on and talk about it. But you know what's interesting? And I think this is happening. Joyce Mahar can confirm. But tonight we're scheduled to have on somebody who was a resident at McLean. In the exact, I think in a different, McLean has at least 2 facilities, as I understand it. I'm assuming there's some very similar ways in which they treat the folks that are there in terms of staffing and accommodations and activities and all. So that's going to be tonight. We'll have her on to talk about, the other side of the coin, which is, I've been there, here's how I was treated, good, bad, or otherwise. Then, boy, we went back and forth, didn't we, when we finally wrapped it up with Dr. Zeisel. I believe we had a cross. You don't get to have that very often. And remember how it works. You go from direct examination, cross-examination, both pretty freewheeling as long as you can make a relevancy argument and beat 403, probative versus prejudicial. Then you start cutting back from there. So any redirect is supposed to address the cross. Any recross is supposed to affect the redirect. Any redirect then deals with the recross. Any recross deals with the redirect. Okay, so we got down to basically one question, which was the very, very last question. Doc, you're not aware that at any point after the subject incident on January 24, 2023, has the defendant attempted to kill herself? And the answer to that was no. So from that, does the jury take that, well, she was faking it all along? Or I'm not sure what that means, because from that point on, she's pretty much been one-to-one. And that was a key point made on the redirect. And that was that at Tewksbury, where she's been for the majority of the time since she was well enough to leave the hospital, she's been one-to-one, as they say, which means somebody is always present with her. And that probably makes attempting to kill yourself a lot harder. Which I'm just guessing. So that question, without further analysis, doesn't really mean a whole hell of a lot. Okay, I see somebody. Thanks, Joy. I try to go through, and if I see a question, I'll start. And you beat me 2-1. So appreciate that. And we'll get to those in a couple of minutes. Let's see other notes. We finally got. He had to wrangle a little bit. Did the Reddington about the lockup, the visits in lockup. Remember, I've been telling you all along when I've been in the courtroom, I would see Dr. Zeisel when the jury's gone, never in front of the jury, but he would always be up there either at the defense table or, as was testified to today, back into lockup with Lindsay Clancy because he's effectively treating her. I wasn't sure that the Commonwealth was going to make a big deal out of that, this weird dichotomy of treating versus evaluating, because it can get kind of a slippery slope, muddy, all those other legal cliches. But it makes perfect sense to me. He was brought in to evaluate her. I don't know that it's unusual that in the process of evaluating, if the healthcare provider is so interested, that it can't sort of morph into treatment. And I don't think that doing one necessarily is a negative on the other. Oh, you're treating her, therefore you can't properly evaluate her. I think the opposite is true. I think you're treating her, therefore you're continually reevaluating, right? So I don't know if the Commonwealth made any points with that, but Dr. Zeisel would go back in lockup, as I told you from the beginning, and he's checking on her. And I could tell, remember day one, 911 call was played, and it was, pretty emotionally chaotic in that courtroom, especially for the defendant. And he was right there, comforting her, asking her whatever those mental health questions are to assess how she was handling the moment. So I could tell right from then that this guy's not just here to be the hired gun expert. He is treating her still. And I don't think that's a bad deal. I do think it's unusual. You don't see it very often at all. Yeah, she has bad days and worse days. What a poetic, powerful way to say that, right? From Dr. Zeisel when asked about her day to day. And again, that came on the heels of all of this. She was wheeling herself around, and she was talking to people, and she was on her phone, and she, all of that stuff that I believe that Bo Buckingham thought was gotcha stuff. And they almost got to, he did focus on, Kevin Reddington focused on a number of things we talked about the last time we got together here when I was talking about the self-propelling of the wheelchair, which was kind of a new thing I hadn't thought about. And we talked about that, how, the custody and control issues mean she's not really allowed to do that in and around the courthouse, but she can in fact do it. So that was interesting news. I don't think it affects the case substantively. I just found it interesting in terms of what the impact on her physically has been as a result of taking the dive out the window. And then she goes, what did you think about the press conference and how he worked around that? I think that could have been a little dicey. It's just like, most attorneys don't want their client speaking. Karen Reed is an aberration. And they generally wouldn't want healthcare professionals involved speaking as they did at the press conference. So he had to kind of walk around that and talk about how, well, I was making observations because he had seen her 3 times at that point. So that was not an evaluation of her. It was a discussion of somebody with certain symptoms and what they would do. And it's very gray. And I could see how it would come off as his opinion of the defendant at that time, having only seen her 3 times. But he worked his way around that. I think as bad as it could have been, it was a little bit better than that. And she asked, those questions. How many times have you had somebody you've evaluated as an expert that you cared for? I think was the phrase she used. Now, I thought the best answer would have been all of them. Just because I'm caring for somebody, let me put it this way, just because I'm evaluating somebody as opposed to treating them, does that not mean on a human level I care about them and I care for them? I think he could have, no, all of them. All of these people I've had the chance to get to know and evaluate and learn their struggles. And I care for all of them. But he just said, well, there's at least one. So there's one other one somewhere that he was both the treating and the evaluating healthcare provider. He referenced that she would call what happened that day because she does talk about it. But remember, we've had a conversation about that. Does she remember it all that well? Well, we knew she wasn't going to testify. I would bet the farm on that. So we will not get to hear her say what she remembers, what happened that day. That would be, well, the word is wrong because we'll probably get blocked, but that would be legal suicide, in my opinion, in this case, especially when I think you're doing very well. So my tragedy was one of the ways she's talked about it. And that was something the Commonwealth found from one of the records. And the doctor said, yeah, well, that's one of the ways that she'll describe it. So obviously the implication there is me. Who cares about the kids or the other lives I've ruined? It's my tragedy, mine, me. And she's still right now, even at Tewksbury, she's on that 1-in-1, where it's basically suicide prevention. So that still exists even today. So the question is, we won't get into a lot of that after the fact medical information, but does she have anything now that would suggest she needs to still be on suicide watch? Is that just a default position because of the history? And is there some point at which she would come off of that? We're not likely to get those answers in this trial anyway. Okay, so a couple of notes here on Ms. Thorndike. Can I get a word in here, Ms. Thorndike? Can I just squeeze in a question? What I thought was interesting was that I guess they physically expanded the building because they started with something less than the 45 beds that they now have. I guess they maybe added a wing. I guess I'm going to miss that somehow, but yeah, added a wing. So they'll have 3 nurses, or is it 4? And that was a little confusing to me too. 4 nurses and 4 therapists and 4 doctors on non-holiday periods. It wasn't clear enough to me. Certainly, even if she had worked through the period in which Lindsay Clancy was there, the way she described the staffing and everything, it wasn't as clear as I would have wanted to put her on to help my case. That's the other thing. Had she been allowed to testify, was she really going to help the defense case? I don't think so. I think the minute issue she was there to hopefully clarify was too minute. I don't think it's not a game changer, especially with the way I think the status of the evidence is now. No great loss. I think, Kevin Reddington saw it. And if you look at the TikTok, if you get a chance, and if we do get her on, I think that was much more effective. But maybe, sometimes you need editing. Sometimes if people aren't questioning you during your oration, it comes off a little cleaner. But if you watch that video, it makes it sound like it was a living hell in McLean. Not so much when she was testifying. And where do I get some of that model magic? Where's that? You get that special, is it Play-Doh that you can eat? Or I mean, what's so special about it? I think she said it was kids modeling clay. Yeah, I'm just looking at my notes on the cross for LCSW Thorndike. Yeah, and I agree completely with the judge's decision. Kind of predicted it, confirmed it when I heard her testify. Nothing to see here, folks. Just way too remote. And what does it add to the mix? Really, not much. I mean, it's interesting. Let's have an adult beverage and talk about your day. That's okay, but stick to TikTok. No testimony. Okay, so let me jump in here. Let me start from which is the bottom. Oh, let me look at the timestamps. Okay, now I got it. Brilliant, Bryant. Zeta Zay, best chat. Yes, there's no doubt about it. No doubt about it. And we appreciate all of that. So thank you guys. Let me see if I can. I always have to keep track of these by, it sounds so violent, but I'm deleting you after I read it. But Zeta Zay's back. Thank you so much for the 5 Justice Serve TV memberships. And they are like, poof, gone. And I keep forgetting, where are we now in the month? The 18th? I need to give away some memberships too. Should I do that now or should I wait and do that tonight when things get kind of crazy? Let me see if I can slide into my own DMs, if that's a thing. Let me see if I can find it. It's always so tricky. Yeah, tricky for you, you doof. It's not that tricky. There are a few options here that I'm trying to find. Nope. Not that. Nope. Let's try this one. Nope, that didn't work either. Doggone it. Clearly something, it's the use it or lose it mentality. I don't do it often enough. And for quite a while, Missy was doing it. And then I stepped in. I can do that. And then proved that it was trickier than I thought. Why can I not find it? I'm so annoyed here. Come on. Yeah, it's like I have to get backstage. Basically, is what I'm looking for. It's a certain part of the YouTube mess that will allow me to hand out some memberships. That is not it. Okay, well, if it comes to me, I'll do it. But in the meantime, moving on. Thanks again, Zayda Zay. Appreciate that. Those memberships that I have not been able to give out, you gave, and they've been handed out. Thank you so much. Okay, so Katie D, why does it matter how she worked out, when she worked out, how much money she spent or lost working out? Why is that even relevant? OM triple-G. Well, here's the deal. Here's what's going on. You have the Commonwealth basically just trying to say that she likes to work out. She's a workout nut. You have the defense saying that's all part of the whole bipolar manic portion of that condition, bipolar being either manic or depressive. So her working out, even as close as she did to the birth of Callan, is part of that whole mental process. It's not just, hey, I'm a very active person and I like to get out there and I feel crazy if I don't work out too much, which I'm sure the ADAs can relate to. That's what it's about. It's about using that kind of manic activity, if it rose to that level, to support a bipolar condition, and that spirals into all of the drugs being used, and the ultimate argument and opinion of Dr. Z that she had a psychotic episode at the time of the injuries and the deaths of the children. Yeah, it does seem a little far afield at times, but that's what it is. And I think, when I marked this Karen Cole, UK lawyer, I remembered what it was you were asking about, and now I can't remember. What was it you were asking about? Well, if you think about it, put it back in the chat, and maybe if I don't see it, maybe Joy, keep an eye out. She may clarify. Whatever it was going on, I said that's a great question but I didn't make a mental note as to what it was. Carly Ann, I think they forgot people in a depressive state or feeling unlike themselves try to do their routine to get out of the funk. And I think we've heard mental health providers say that it's the life routine that can give you the structure that may make you feel better about whatever it is that's weighing on you, whether it's anxiety produced from postpartum condition or whether it's drug induced, whatever it may be, trying to add some normalcy to your life so that control and that routine grounds you a little bit. I think that's a good point, and we've seen that from, I think, at least a couple of the records, or here, since we just had Carly Ann, I just want to hug Paul. When I'm back up there next week, I'll give him a hug for you. Carly Ann, I will give him a hug. Tell him this is from Carly Ann. Okay. Yes or no? She's trying to get a gotcha moment. Well, I think that this could apply to many different moments with Bo Buckingham, G-Momo F7. There were so many. I mean, that seems to be, and I think it's a sign of desperation when you can't really just lay out substantive issues that either support the Commonwealth or take down the defense position. You're looking for random gotcha moments, right? From remote cases that somebody handled in the case of Dr. La Posada from yesterday, which I think backfired on her. I think it's interesting. Who was I reading and then I commented on? It wasn't Ian Runkle. Who was it? Dang it, I can't remember offhand. But their point was that Dr. La Posada lost some of that cross-examination because of bringing up this older case. Oh, I know, it was Lawyer Lee, who I haven't seen in a while, and hadn't seen her. She hadn't been in my DMs in a while. So I was watching that, and I said, I totally disagree. She was suggesting that the back and forth between the Commonwealth and Dr. La Posada on this case from, was it 2010, 2011, in which a young child had been manually strangled, that somehow that Dr. La Posada's attempt to educate the Commonwealth as to the difference between ligature strangulation and manual strangulation made the doctor look like she was, making stuff up or being less effective or not giving an excuse or an explanation that made sense. It made perfect sense on a common sense level. If I'm doing this, I don't have full circling around or even pressure around my neck. But if I have a ligature, I do. And then, of course, we got into that dumb demo, the dramatic demo with the exercise bands that I didn't know, because where I was sitting in the courtroom, the lectern covered her little demo. All I could do was see her pull it out of the bag, got to put the gloves on, pull it out of the bag, and then she did something. And then so I looked at it on a replay and saw that I thought she was wrapping it around something, just to give a little better illusion of what she was suggesting was the case with the doctor. And the doctor could only see kind of part of it, but she knew enough to respond as she did. That isn't how it happened. If you go by Patrick Clancy's testimony, he loosened the bands, which were, I used to have one around here somewhere. That was, props are so helpful in doing just what I'm trying to do now, and I don't have one handy. But because of the elastic nature of the band, if you put a half knot, and a half knot is, if you're tying your shoes, a half knot is the first part, and then you do the bow. If you're doing a square knot, it's half knot and another half knot. That equals a square knot. So if it was just a half knot, which is how he described it, and you've got friction from the material of the stretchy band, that's going to maintain that pressure point without anybody touching it. Now, at what point does it come free or loosen a little bit? That's going to depend on the movement of the person whose neck it's wrapped around. If they're unconscious, remember the point of unconscious, 5, 10, 15 seconds, right? So at that point, they're not struggling. The band stays in place, continuing to add pressure, and then death occurs within a relatively short period of time. But for the Commonwealth, they want to create the picture of the defendant standing over each of her little children, just holding their neck or holding that ligature in place for 10, 15 minutes. That's the image they're trying to create with this jury. Now, for their position, I can't disagree that, yeah, if they can, good luck. If you can paint that picture, it will definitely help your case. Did the doctors give her samples? That's a good question about, the whole med thing. These guys, the Commonwealth is so married to this, hey, here's a prescription for 30 pills and she only took 7.5. Here's a prescription for 15 and she only took 4. We have no clue what she took when, because there is no medical evidence of the baseline or the metabolites in her system, no blood tests. So we don't know what she took. And she's not going to pop up there and testify about it. So all we know is, maybe she took 5 of the pills and threw them in the toilet. We don't know, because they didn't do the proper testing, which is part of the bigger problem here. So, and what if there were samples? Sometimes, crazy idea, but the doctor will give you, here, try these, and let me know how that works out. And then maybe we'll prescribe some more. There's a reason that drug companies give doctors lots of their meds for free so they can sell them. So doctors will give them out either to test them out with the patient. Maybe they have a patient that doesn't have great insurance, so here, have a few more of these. But that's possible. There's no evidence in this case that there were samples given, but it happens. I had a couple of friends who were professional drug dealers, which is what I call these folks who glad hand the doctors. What a racket that is. It's a sales job. God bless you. I've never been a salesman, but you got to be like, hey, how you doing all the time? You're always on. You're taking the doctors out for lunch. You're taking, they get wined and dined, so they will stand behind and prescribe these various meds. It happens. That's just it's the and they make decent money. Anybody in sales makes decent money, but selling drugs, it's the used car world of the medical profession. It is, and I mean that only in a slightly derogatory way. Anyway, yes, could have been some samples in this case. We don't know. No evidence of it at this time. But to me, it reminds us the point that we have no clue what she took, when she took it, how many she took. None of that. That's very possible. Mag in Florida, free. Lindsay. Oh, Mag in Florida, free Lindsay. Jury working on a grocery list. Yeah, I will say again, they've been very attentive, very note-taking to varying degrees, depending on the witness. There have been some witnesses where I swear 12 out of 18 or more are writing at the same time. There are people with, what do I have here? They have these bigger notepads than I do, but they got a lot of notepads, that they're working their way through. Some people aren't note takers. They just make mental notes of the things. And I think their position is, hey, if I don't remember it well enough, how important was it? I know people are like that. I've talked to jurors after the fact. You got the big note takers, and you got those that are like, I'll make a note of it right here if it's important enough. So, and is it possible somebody's making a grocery list? It is possible. There are some downtime. Not every bit of testimony is riveting, pencil to paper kind of stuff. So this cross proved LS is intelligent. She knew her husband's phone number. I think we're talking about LC, not LS, the lunatic she-devil. That's a whole different thing. She knew her husband's phone number. Dr. Z makes $300,000 a year, and LS was taking 3 meds, not 2, and is bipolar. Again, LC. And is bipolar. Anything else, chat? What did you guys add to that? Did we learn anything since this was done? This was posted at or about 11 this morning, so might have been many things that popped up after that? Okay, here we go. It's very clear that the ADA has never lost a person. Otherwise, she knows on the days you are not always, oh, I see, there are days you're not always crying and staring at the walls. Yeah. And that is a theme they're certainly trying to create here. And that is that from the moment that she realized what she did, and again, they think she realized it not just at the time, but planned it well in advance. But after the fact, you should just be reflecting on it and crying your eyes out and, be catatonic. And I don't think any of the professionals would agree with that. And we've not really had any testimony that would suggest that. In fact, the opposite's true, that if you are psychotic, and this is the very tough thing, I think, for most humans to get their heads wrapped around unless they've experienced it. I've never had a psychotic episode, at least not that I'm aware, but you are functionally about as normal as you could possibly be. You can drive to the store. You can go shopping. You can go take the dog for a walk. You can do all of those normal day-to-day things. You can't learn anything new, according to Dr. Z. But you can do anything you've ever done, and your intellectual capacity is not injured. It's not damaged. It's not on hold. It's still there, grinding away. But inside, you've got this something happening that detaches you from the reality of what you're doing. It is it can be difficult to grasp that concept. And that's the key for this defense. They've got to get the jury to believe that. More nuanced, the Commonwealth has to get the jury to disbelieve it. Okay, so once the jury has that issue in their hands, the Commonwealth has the burden to make them believe it didn't happen, could never have happened. And I'm telling you, if they follow the law, that is a tough mother to prove, or in this case, to disprove. Okay, Lee Bug. I mean, in that case, they also need to impeach Patrick for his statement claiming he had to untie the bands when yesterday the Commonwealth claimed they were not tied. Yeah, I don't understand. Did they forget their own case? Did they? That was one of the most, gut-wrenching parts of the first 2 days during his testimony, not just the 911 call, but his graphically going through how he found the children and what he did. I mean, how do you forget that? How do you then try to sell this jury a totally different story, that the bands were just kind of loose, just kind of flopped around there? And when they said wrapped around multiple times, I have a question about that as well. My mind's eye saw once around with a half knot. Okay, now were the bands, the excess part of the bands, then overlapping one another in some sort of way that was not functionally constricting the airway or the blood flow? That's a little unclear to me, but I had very clear recollection of the half knot. I mean, I could picture it. And then, hearing the 911 call, picturing that, that's that was some tough stuff. I appreciate this channel and chat. Yes, and we do value all opinions here. People tend to gravitate, to an echo chamber. Hey, they don't think the way I do over at XYZ, so I'm going to go over to LMNOP because LMNOP thinks like I do. So that doesn't mean we don't want, other opinions. Bring it on. If you can bring an opinion that is something other than name calling or fat shaming, or there's a lot of fat shaming in the chat, and I know it's an easy thing to do because the ADAs in this case probably could lose a couple of pounds, and they're not very likable, and so it kind of manifests itself as little snarky comments about how they look. That aside, if you can make a point and support it with something, bring it on. I just don't like cheap shots because they're lazy. So but alternate opinions, I don't care. As attorneys, we deal with alternate opinions all the time. Sometimes we have to put on, one day we're arguing this side, the next day we're arguing this side. So we appreciate that. You just need to support it, not just throw out some, vapid comment because you feel better when you do. The problem is this judge is on thin ice and mistrial. I don't know about that. I do appreciate Sir Paul Bolduck, LLC, popping in. I've seen you more recently. I don't remember you being around all that long. We appreciate it. And I'm guessing, are you an attorney or just you've got your name is a limited liability company? Anyway, I don't think that's necessarily true. Yes, the whole mortal moment, the mortal sin moment from yesterday. Yeah, it's kind of rubs you the wrong way, and it could have been. I mean, you can always ask for a mistrial, based on very little. You can ask for a mistrial. And there's been a lot of discussion online about whether it should have been granted, would have been granted, would be right to grant it. I think it'd be a major mistake for the defense because they're winning, in my opinion. So why do you want to even attempt to start over? You don't. But I don't know that substantively there was enough. It's maybe there's far more. I should say far less drastic remedies. Remember, there's a request for mistrial has a lot of potential remedies. You don't. It's going to be denied, but you could also ask for various sanctions, like this witness's testimony in its entirety should be disallowed because of that. But it was a defense witness, and it was the Commonwealth making the bonehead move. So how do you punish them for what they did wrong and still keep the defense case intact? And I think it would have been more punishing for the defense to let the Commonwealth manipulate the system by asking a question that was clearly out of bounds. And maybe I'm not giving them enough credit for deviousness. Maybe they knew that, feel like they're getting tanked in this case, and hoped that the defense would move for a mistrial and, kind of wink, wink, would be outraged at the thought. I don't know. Are they that smart? I don't know. I certainly don't think they're that self-aware. I don't think they believe they're losing this case at all. I think they're not happy with the way it's being portrayed, that the defense is definitely getting the best of them. And I think they know that it could be better. Let's put it that way. All right, Brass 6073, member for 15 months. Thank you so much. I've barely been a member 15 months. Contrast between conduct of Zeisel and Tufts is obvious. Yeah. Well, you have to remember too that Tufts is sitting there as the primary defendant in a massive civil lawsuit. So not quite as freewheeling as Dr. Z might be, who's just sitting there. I love the guy. He's doing a great job. And as I've said before, we're going to get him on for an origin story. But, you're sitting there doing your job versus sitting there, kind of testifying for your life. I mean, what happens in that civil case could have major implications on her profession. And so I can't put their quality of testimony in the same bucket. Addie Martinez, realtor. They're trying to say that he has preferential treatment towards. Yeah, this is the issue I sort of touched on when we talk about Dr. Zeisel's role as both a treating physician and an evaluating physician, and not a physician, I shouldn't say that, healthcare professional, and his connection with the defense, Kevin Reddington. I think it's very clear. You can argue that there's bias there. That's fair game for cross-examination. The jury ultimately will decide based on how they perceive this witness, whether it's true that he's favoring the defense because he's buddies with the defense attorney, or whether he's being objective. Some people are going to take to that simple bias based on their own life experience. They'll go, well, the guy's my boy, so I'll do whatever he needs. Not the professional way to go, but they could think that because in their own life, that's what they've seen. On the other hand, people could say, well, look at Dr. Z. He seems like an honest guy. He's admitted mistakes when he made them. And he got to Lindsay Clancy through his friend, but I'm not going to hold that against him as long as I believe what he's doing is the right thing and I respect him as a professional. Those are the kinds of things the jurors are going to be wrestling with. And then you get back in that deliberation room, hopefully those discussions take place. Hopefully you have somebody that's saying, hey, this guy's just a shill because his buddy is Reddington, so everything he says is just trying to help his buddy. And then you have somebody else, I think, more rational, saying, well, where do you get that? You're making that inference just because of the connection, not because of what you heard or what he did in treating this person. He treated / evaluated her more than a lot of any physician might do in any circumstance. And he admitted, it's rare. I don't think he used the word rare. He said, it's not typical. It's not typical, but he has spent that time and effort. Now, that extra time and effort may be because of his friend connection, but does that affect his ultimate opinion or conclusion? Those are the discussions the jury's going to have. There's nothing. Look at this. I'm trying to nothing personal, Sir Paul, but I'm trying to remove comments I've talked about or questions because then I don't go over them again. You've done something weird, Sir Paul. I can't get rid of that one. It won't go away. I don't understand. Yes, that one. Okay, now watch this. You won't be able to tell, but I just hit it first of all, and then I hit delete, and guess what? It's gone. But the one from Sir Paul won't go away. Okay, Karen Cole. Now I want to know what the wish egg is. Oh, I did a little bit of research, and according to my friend AI, there's no specific Hawaiian item known as a wish egg. There is something they talk about. Let me see if I closed it out. It might still be here. They have a wish granting egg, which comes. It's also called a cradle of desire. It's a fictional oval artifact from the popular anime and manga series Made in Abyss. I have no idea about any of that. But when I looked for wish egg and Hawaii and put all those search terms in, I got nothing. So I don't know what it is. I don't know why it was objectionable unless it's just totally irrelevant. I'm assuming he was going somewhere. I mean, he had it. He had it, the egg or whatever that is, the oval thing. I'm assuming he was going to be talking about how they had made some lifelong wishes together and, something that would look like there was this amazing bond between Lindsay Clancy and Pat Clancy. Well, they were there in Hawaii for their honeymoon short after their wedding. It is, based on what I know, totally irrelevant. And I would think that was the objection and the fact that the judge said, we're not getting into the egg. All right. We're not getting into the egg. I know we're going in stops and starts today, but we're not doing the egg. All right. So did the Commonwealth never get the McLean? Yeah, we now know they got them. And I think that to me is the best answer. If the jury wants to look at them, they're in evidence. We didn't hear whether, unless it was just tossed away as an aside, whether Kevin Reddington said, yes, Your Honor, we'll have those put into evidence. Sometimes you got so much going on, so many pieces of paper flying around, so many people and so many witnesses. You got to really take a breather before you rest your case that all of the evidence is in, that you've moved everything into evidence that you want into evidence. Nothing worse than, Judge, I'd like to move to reopen so I can give you these 5 pieces of paper that I forgot. I know. It's embarrassing. The clerks don't like it. It messes up the whole system because remember, all of the stuff that's in evidence is going to be schlepped into the deliberation room. A lot of it these days is on computer, which is helpful. But I like to hold and touch the stuff, and so it's just a practical matter. Take a breather and say, okay, is everything in? Normally, you would have an associate, an underling of some sort, who's tracking that kind of stuff. But Kevin Reddington is he's the one-man band, literally the one-man band. And so he's counting on the clerk and, his own record keeping. And maybe his son is doing that, behind the rail. I met him, chatted briefly yesterday. Nice guy. I wanted to get into the conversation with him about, so is this Dad's strategy to keep you, away from the table? So it looks like, poor Lindsay, and when I'm exercising the cross-examination or the direct of a witness, or we're in a sidebar, she's there just by herself. I didn't get around to that, though. I'm not sure he would have answered, but I didn't get around to it. So they got the records. Hopefully they will go in. And if the jury cares, they'll take a look at them. If not, I think it was a relatively minor issue. This testimony seems more appropriate for civil trial to me. We were talking about, I think that came in, reference to 1244. So that was in reference to Miss Thorndike. Apparently not relevant for either. And again, because of the timing, you can't lay the foundation for relevance if there was a disconnect in the time this witness was at McLean and when the events subject to this case or the civil case were happening. She wouldn't be able to testify in the civil case either, in my opinion, for the same reason. You know, she wasn't there. So who knows if, you know, she left on, what was the day? I think I wrote it down here somewhere. It was toward the end of the year. She wanted to basically collect all of her vacation before she walked out the door. So she was there until like 12/18, I think it was, in the year 2022. We don't know for sure that the next day they didn't change staffing to the degree that it would have made any testimony she gave totally wrong, not just irrelevant, but misleading. So I think it was good that she didn't get to testify. I called it early on. It didn't change when I heard her testify in voir dire, and I don't think she's appropriate for the civil case either. And that may or may not be an issue in the civil case. Who knows? I mean, if you're suing McLean, certainly you're going to be attacking, you know, the level of staffing. Would the judge limit what she can testify to if he allows her? Yeah. Yes, Mara, J17. That is correct. And it was going to be. We knew that he was only looking at it. I thought it was dead in the water right out of the box. But when he focused in his early questioning last week, before Thorndike turned in her TikTok for testimony, he was clearly focusing on the staffing. And I said, well, you know, maybe I needed to know more. And now that I know more, you made the right decision. Get out of here. Why is Bo going so hard at her? And they're really afraid of Emily from TikTok. Bo Buckingham is a hard ass. She goes at everybody hard. And sometimes it pays off. Not often. Sometimes it looks like she's a bully. And that's kind of what it looked like here. I mean, you give so much more weight to a witness by being that aggressive against that witness, because people are like, whoa. Of course, the jury wasn't watching this. We are, though. It's like, what is she afraid of? Why is she working this woman so hard when, let's face it, even if she got to testify, it's, you know, it's kind of a, all right, so what? Which is why she's not testifying. But I think it's more a function of two things. I think it's just who they are, style, presentation, and the sense that they'll admit to themselves they're losing. And so everything you do becomes more desperate. I'm losing. You know, coming up on, it's like the 7th, 8th inning. I'm down by 5 runs. We got to, you know, I'm pressing. Hey, Coco Gaga, in your opinion, what will the verdict be? Well, that's always a fool's game, and I'm ready to jump right in. I've just said from the beginning, and nothing's changed my mind since, that the Commonwealth will be very lucky to get a hung jury. Now, that doesn't mean I think that's going to be the verdict. I think that's the best it gets for the Commonwealth. We don't know yet what the other choices are going to be. We know first-degree murder, of course. We know second degree has been talked about. Then we know not guilty by reason of lack of capacity or lack of criminal responsibility. And that's the key issue that Kevin Reddington got into today, which, of course, is the mental disease or defect, which gives you the inability to form the intent you need. In Massachusetts, they call it lack of criminal responsibility. That's on there as well. And then there's a good old-fashioned not guilty. That, I think, would be, if that were to happen, I think that would be a nullification issue. I think they would be finding that despite all of the evidence. And that is what nullification is, basically a ruling, a verdict that is contrary to the evidence that you've seen. I think there's plenty of evidence, not that she did it, but that she was impaired at the time. So I don't know how you get to not guilty in a case like this, because we know she did it. Okay, so that's my non-answer on that one. How many rebuttal witnesses does the Commonwealth have on their witness list? Yeah, Kayla O'Leary, am I close? We know of 3, and I don't know that they're necessarily on the list, because there is some leeway with rebuttal witnesses, because remember, if you look at the main cases, pretty wide open within relevance and 403 context, then you have the rebuttal case, which is designed to address only the defense case. Only. You're not supposed to be able to circle back and go, oh, damn, I forgot, you know, A, B, and C in our case in chief. Let's get them in here. Let's do that. No, it's not going to fly, especially with Kevin Reddington. Unless he sees them trying to do that and it's something that hurts the Commonwealth, then he might just do one of these. Do this Kevin Reddington. You don't have to object, but I expect that they're using these 3 doctors to specifically rebut the belief we heard today from Kevin Reddington that she suffered from a mental disease or defect in the form of psychosis caused by postpartum and some overlay of the meds. And I think we're going to have doctors that say, no, that's wrong. She was perfectly sane. Yes, she had depression. Yes, she had some of these other issues they were trying to treat with meds. That did not stop her from forming the intent necessary to carry out these premeditated murders. I think that's why I think premeditated too is a reach. You know, why do that? You know, because there are lesser includeds here, it does cover the Commonwealth's ass a little bit. Because if it had been all or nothing, which is if I'm the defense, that's what I want. I want all or nothing. I want you to prove premeditated or we're done. Not what's happening here. There's going to be some lesser includeds, and they can be compromise verdicts. There can be people on the jury that say, yeah, she did it. Yeah, she was having some issues. She was struggling, but we're not letting her, you know, walk as a result. And walk is probably the wrong term in this case. Oh, here's the update on it. Thanks, Joy. Special guest this evening was at McLean, went through these steps that Lindsay did. She was there for 5 days. Lindsay was there 5 days. We'll see how long our special guest was there so we can draw further parallels to her treatment there. And thank you for coming on, by the way. That's very brave to do that. I'm sure it was not a high point of your life. Lee Bugs, do you think the trial will actually help our mental? I hope so. You know, when we started covering this 2 years ago and nobody gave a rip about it, now it's this case celeb. I've seen it. I've seen 10-minute segments, which is a lot of time in, you know, cable news on this case. You know, most of it superficial. Most of it I've found the hosts are much more, let's get Clancy, much more prosecution oriented because they don't know the case. And that always happens. In the next few days, there will be, you know, I always talk about the massive parking lot there at the court, which I love because no matter when you get there, there's tons of room. It's going to be filling up. The people, they're parachuting in. Here we go. People from all over are going to be coming in, becoming an expert on the case that they know very little about. Well, right now, that's what happens with these cable news channels because they're hearing the buzz. They are hearing the clarion call, as it were, from, you know, the people that are going to make their demise online, where people get the information they want. They have many more options. Main Street and Lame Street media watches and monitors. You know, they have their own little side channel, perhaps, and they have, you know, 19-year-old and 20-year-olds paid them, you know, $20 an hour to be monitoring what's out there. And then they go, hey, this is the, and then, oh, all of a sudden it's an important story for them, right? And so they dive in knowing very little about it. And you can just tell from the discussions. Because at first blush, you think, oh my gosh, his mother killed her 3 kids. And that, I don't care how it happened, inexcusable. And I think that's a starting point for a lot of people who aren't really in touch with this case or what the evidence has shown so far. So to answer your question, I hope so. I mean, our healthcare system is effed up as it is. And I think it's even worse in the mental health side because it's just so touchy-feely. It's, you know, I can fix a broken leg, says one doctor, not me. But a broken mind, I think the mental health system, because of the subject matter, is far more impacted by all of the little things that happen in the medical community. You know, insurance overrides, not enough time for patients. That's partly an insurance issue and partly a practice issue. There's just too many people that need the help, and so you don't have enough time. You put that process into the mental health field, and the trouble is magnified exponentially. And so I hope there is some improvement. And I'm not going to get in a discussion about universal health care, one of those things. Okay, Lyndon 1974. Thanks for that. I could use a treat. And they have, but this place I stayed up there, nice little place. I would recommend it. It's high time right now because it's summer and Plymouth is kind of a touristy destination. Let's go look at the Rock. That's it. I'm sure that's the reaction from most everyone. That's it. Well, it's, it's like, I don't know. It's like a small car, but it's not Plymouth Rock. You think like Rock of Gibraltar. You think, oh no, it's not. But it is that part of New England this time of year, super busy because the rest of the year the weather sucks. Anyway, so it's not the cheapest place to stay, but a nice little place. amazing breakfast. I was able to load up on that before I hit the road for the court. And I don't know where I was going with this. Oh, treats. Yeah. And they'd have, I'd grab a couple of things. Hey, and take this, I'll have this at lunch. And let me thank again my friend. I won't give her name because I didn't get her approval on that, but she's Bob Mata's local connection. I'll put it that way. Bob Mata, of course, Defense Diaries in from Chicago. And every day they go, you want to go get some lunch? We're going to do. I said, no, I'm going to do this Q&A. I always do this lunchtime Q&A, and I have my little Cliff Bar or whatever. I'm fine. I'm not complaining. But she said, I'm going to make you lunch tomorrow. And she brought this lunch that I had yesterday. It was amazing. It was chicken salad on some sort of grainy kind of bread, some very cool chips that were, like kind of like kettle chips, and then a big thing of grapes. It was like, and I'm driving home after, and I realized I wasn't starving. And that's why. Instead of the Cliff Bar, I had this, like a 3-course lunch, which was amazing. So thank you again for that. I do appreciate it. I never expect, but I definitely appreciate. All right, thank you, Brass 6073. Appreciate that. I work in a hospital. There are periodic evaluations to change a patient's constant safety observer status. Constant safety observer status. It can stay 1-1 or it can go down to 1-4 or none. Well, that's interesting. Interesting gradation. 1-1, I get. 1-4. What? And I can get none. None makes perfect sense. 1-4. What are they seeing? What are they hearing that says, look, we need you to kind of monitor 4 people? What are they? What is it? If you know, Brass, let me know. I'm just curious what gets you to that mid-level. That seems to be a little kind of squishy. Do we know what health insurance Patrick and Lindsay had? No. No, but if you look up the if you get into the civil case, and we may at some point, just to see how it parallels what happens here in the criminal case, because I think most people are pissed off at the doctors involved. Why? Well, let me show you my chart. Here they are. We're heading this direction, and we're not. And we're going all of these folks are the ones that are the targets of the lawsuit. In fact, of those we've seen testify, only nurse practitioner Paul is not a defendant. And she's the one that had very limited contact, and then she was moving, and so she handed it off to Lollapalooza, as you'll remember, nurse practitioner Gelada, Lollapalooza. They're all in there. They're all part of the suit. So it'd be interesting. We may keep an eye on that. But in that case, you're going to find a little more about the insurance companies, which I believe, after this case, are going all in. Policy limits, here you go. Sometimes they call it an interpleader action, and it's where you have a third party that holds the money, and one of the defendants says, look, this is all we got. I mean, we're judgment proof beyond this policy limit. So here it is. Knock yourself out. We are no longer fighting over it. And I think that could happen in this case. I just don't know how many there are. Does Karen Reed still have 2 doctors to question? Well, we know, we believe Spinelli's coming in, and Dr. I always forget his name. Renslick, that guy. That is supposed to be a video, another Zoom witness. So I know of those 2, but that doesn't mean there won't be more. But I believe you are correct on that, Dr. Sue. Thank you, Dr. Sue. That could be a malpractice doctor, Dr. Sue. Okay, Bonnie Petrini Cola, 110. Why was an EEG not given? This can show postpartum depression and brain reaction to medicine. Psychiatrists, neurotherapists, neurologists are able to order and or perform this test. I don't know. You know more than I on why it wasn't, or why it could have been given. I have no idea. There's no testimony. And the question is, that sounds even simpler than the blood test, which we know was not given with the interaction of these. Have I shown you my chart? Yeah. There was so much going on independently that nobody was steering the ship, as I've said. And I think the lack of an EEG, part of that failure. Put that in the lawsuit, would you? Oops, did that one already. Sorry. There we go. We Are Charlie, 1971. Former Massachusetts Judge Carol Erskine, yes, and Mark Garagos found a 603 or something that would qualify, as grounds for mistrial without prejudice. Without prejudice, that's the key. Without prejudice, which means it could be retried. Remember the Alec Baldwin case in New Mexico where that prosecutor screwed up and took some of the bullets that had been collected and mislabeled them and put them in like a different part of the evidence room, whatever they call it, the bin, the room, the container, so that they could never be brought into that trial. And the thing was, I'm not sure they ever did much to connect them to what was going on. Remember, there were a number of shells. There were 5 or 6 shells that were in the gun that ultimately ended Helena Hutchins' life. But the court found it so egregious that they hid this evidence that could have been exculpatory. That was never concluded, but so what? It was so egregious that they said, this case it's a mistrial with prejudice. So prosecutor boys and girls, you're done. If you have a mistrial without prejudice, it can be replayed. And like I said, I don't think the defense wants that. But I do remember the cite they made, and that was that you're not allowed to get into a witness's religious beliefs, which obviously they got into with the, are you a Catholic? Do you know that murder is a mortal sin? Yeah. So again, be careful what you wish for. I do not think anybody on the defense wanted a mistrial, and especially don't want one without prejudice. If they get one with prejudice, yeah, take it. But that is so rare, so rare. Hey, our beach caregiver, how are you? Always good to have you. You're back. You were gone, and you're back. Back as a YouTube member. We appreciate that. Thank you. We're giving ourselves jewels now. Is that appropriate? I'm not sure if that's appropriate. I'll have to investigate that. See, I've got a couple of others. Now I've got a couple others that, I'm just trying to delete them just to clean up so I don't circle back and do the same ones again. They won't delete. I don't know what it is. Large Marge, records go in with no testimony about them. Can they be used in closing? Oh, sure. Yeah, there was no objection to the records. In fact, I think the Commonwealth felt it was a win to get, if we're talking again about the records from McLean, which is what was the subject of Miss Emily Thorndike's testimony, I think Commonwealth is thinking, that's a win. We got that in instead of her testimony. And I think the defense is probably thinking, fine, records are in. They can both argue them if they want at closing. And I would be surprised if they do. I think they do restrict the time to a degree. We haven't heard this judge say, I'll give you an hour each. The Commonwealth's opening was 20 minutes. And I replayed that last week and went through some of the promises kept and promises denied. I think Kevin Reddington was maybe 30 minutes, maybe 35. So I would think drip and wet, we're looking at an hour each. So they may decide it's not important enough. It was something, but without being able to flesh it out. If you had a witness that could come on and say, on that exact 5-day period, they had half the staff they normally do, something, then yeah, maybe it's worth bringing in. I just don't think it's going to be worth talking about. I definitely wouldn't be bringing it up, but I would make them aware the records are there if they have a question about it. Definitely. Coco Gaga, 2 jewels. Thank you. Thank you for the silver star. Okay, they said, I think the judge said they were going to come back at 2:15, which is what we're coming up on here very quickly. So I will peruse. Oh, I wonder, I don't think I can, I got an error message that says, try refreshing the page. I don't think I can refresh the page without basically losing us. So I'm not going to do that. I was just trying to delete some of these questions to clean up. And that's when it said, error. Okay, yeah, I'm not going to touch it. Not going to do it. So let me go back and see. Any other questions, folks, before we toddle out of here? Tonight, again, we have, I'll come on at the end just for a quick touch-up. Tonight, we'll have our official recap. And then we're going to have, we got a couple of guests. One who actually stayed at McLean, the Institute, not the exact same one. They have 2. As I understand it, but she can give us insight as to what it's like to have been there as an inpatient. Okay, so we'll do that, and then we have because of this mistrial issue that everybody's all gaga over. We're having Michael Del Senor on. He's been on. He's one of our Massachusetts experts. We've had him on a few times to talk about the various procedural things going on. So we'll talk about that, and I'm sure that rule that that Judge Erskine mentioned and others have talked about. We'll get into it just to a degree, but I think it's more a philosophical question than a procedural question. Yeah, we knew the request could be made and perhaps would be granted, but why do you want it? Why do you want it if you're the defense? If somebody could tell me in certain terms I could get it with prejudice, bring it on. I would do that. You could ask for it with prejudice, but what happens then if the judge says, I think a mistrial is appropriate, but I'm granting it without prejudice? Well, then you're screwed. So you guys are just so evil with the twins, man. I realize you're focusing your anger. But yeah, I'll give Karen a plug here. Karen Goldberg, YouTube. The Coffee with Karen, I believe, has been ripped off, gone, shut down, I think. So Karen Goldberg 8 on YouTube is now her current channel. I'm not 100% sure. Check that out, but I think Coffee with Karen is the one that got hacked. And we're going to have her back on. She's going to be, I think she said she's going to be back up there tomorrow. We'll see. I also noticed our friend of the show, Lauren Conlon, she jetted in. And I think she's going to be on tomorrow. I asked her if she could get on today, but it was her first day in the courtroom, and I'm sure she's got a bunch of stuff happening. She's got her own stuff to do for LA Magazine. But we love her, and I'll run into her on Monday. She's going to be there through the end. It's going to swell. The courtroom is going to swell with media types that are just joining the fray. Okay. Well, he was here a minute ago. He's been in, he's been out. I showed him earlier. Did you, Donna Q, 594. Did you see Domino? He was here. Oh, wait a minute. I didn't see this, but Air Beach Caregiver thanking Linda for the information on WishPot. Is that the same thing as the Wish? What was it? What was they called it in the trial? It wasn't a Wish Pod, was it? It was a Wish something else, and I couldn't find anything. So you're saying it's called a Wish Pot? Let me see. Let me double check here. Oh, Wish Egg. That's right. And Wish Egg was not did not come up. Hawaiian. Let's see if I put Wish Pot, it comes up in here. Of course, we're not going to find out what it had, what was going on in their Wish Pot, but I think we could guess. Wish Pot is, in the context of Hawaiian art, usually refers to the Wish Keeper. A signature handmade ceramic vessel created in Hawaii by artist Matthew Lovin. First designed in 1992 after the artist saw it in a dream. This raku-fired art object functions as a symbolic vessel to hold personal hopes and intentions. So I think we can understand what might have been in it from their honeymoon in Hawaii, and also why it was not allowed. I will not allow it. Okay, this is clarification. Karen's new X account. Follow our friend Coffee with Karen on. Yeah, Goldberg. Oh, Goldberg Me. That's what it is. Goldberg 8 is still her YouTube. Is that right? And her new X is Goldberg Me. It's always a good question. Do you have another trial in mind of covering next, Michael? Yeah. We were all geared up to go do OnlyFans in the death of Christian Obamseli. That was resolved. And man, the sentencing, I believe, is December, but she basically took a deal for 6 years. She's already been sitting in the tank for 4. You give her good time, straight time, or whatever they call it there. They do 85% in Florida. So if she does another year, it'll be a lot. She could be out in less than a year. So I think that's a sweet deal, because I think people would have hated her. When they started seeing these videos, and we started prepping for that trial, and we're showing some of the video, definitely a domestic abuse issue going both ways. But most of it looked like her being a bitch. I'm sorry. And I think the jury would have hated that. And I think 6 years, considering what she's already spent. Let's just put it this way. If you're going to re-up your OnlyFans subscription, pretty sure first of the year she'll be ready to rock and roll. So there was one that I actually just got this the other day. This is an amazing case in Michigan that we may or may not get into. I've talked to Kathy Russin at Law and Crime /Court TV to see if they're going to cover it. It's still on their if list, but it's called Michigan versus K.C. Grondin, Kenneth Carl Grondin. Anybody familiar with that case? This is a retrial that is fascinating. 20-year-old victim found dead in the basement of the home in Mayfield Township, Michigan. Why is he out and why is he being retried? All good questions. And we'll get to those if we're going to dig into this case in some detail and perhaps cover it. But it is the most important part of it is reversed on appeal. I think the verdict form was the issue in this case. Reversed on appeal. In the interim, DNA connected to somebody else who is now in prison for the same crime that this guy is being retried on, but they're still retrying him. So that's called Kenneth Grondin, Michigan versus Kenneth Grondin. So that's kind of on our short list. We'll see. Obviously, if it's not being covered, we can't do much about it. And then we have, obviously up in Massachusetts, October 5 is the Sandra Birchmore case, Matthew Farwell. Federal case, though, no cameras. So I definitely plan to be up there, to dip in, to bring some sort of life to what we can't get in and see. But I don't know. Well, it'll depend on how long it is, what our presence is going to be there, but definitely going to be covering that to some degree. And of course, Aidan Carney's trial is coming up, Pearl Harbor Day, December 7th. So there's always stuff. We're trying to kind of branch out and go beyond our little world here in the Northeast. But we just keep getting, in the words of Al Pacino, just when I think we're out, you pull me back in. We keep finding, that was a horrible Al Pacino. We keep finding, that these cases that resonate with people, and that's what we're trying to do. If we start talking about this case, Grondin, and there was zero interest, and I'm not beholden to the YouTube algorithm, in philosophy. We are in terms of a business model. We need to get looks and we need to get promoted. But if a case doesn't resonate with YouTube, but it is with our audience, whatever the size may be, I'm okay with that. So that's part of what keeps us the best kept secret in true crime. You don't tell anybody. Shh, quiet. Keep it on down. The last thing we want is more people knowing about us. Shh, quiet. Yeah, let's some shout outs for our people. Karen is really good. She's so real. And I mentioned she was in the chat earlier when I was talking to Kevin Reddington yesterday, and I said, I hear my friend, if I may call her that, Karen Goldberg held you hostage for about a half an hour. And the first thing he said was, do you believe she has 8 kids? And I said, no, I don't. And then I didn't even get into the next level. She does this and this and this. Every time I talk to her, it's a new profession. I'm going to have to do some vetting because it can't possibly all be true. Love Lauren Conlon. Yep, she's great, Sheila. We do. Oh, this is interesting. She'd be happy to know this. Karen just did a lunchtime. It's weird because I get her on Karen with coffee and I don't know why. So I'm a little confused then. I'm not sure what she lost and what she's resurrected. Why don't you tell us? Tell us, Karen Goldberg. Karen Pearls Goldberg. There's got to be a story behind that too. She wears pearls all the time. Okay, so here's the answer. It's called Coffee with Karen in YouTube, but it's Karen Goldberg 8. Oh, so wait a minute. So the title is not Where to Find You. So we're Just to Serve TV, which happens to be Just to Serve TV. But you are Coffee with Karen, but you find it at Karen Goldberg 8. I think I got that right. Okay, I think we got it covered. Wait, is this right? Yeah, this is more on the wish pot. Traditional ceramic vessel rooted in Chinese folklore used for intention setting. You write a wish or goal on a small piece of paper or scroll, place it inside the pot. Yeah, so again, I think we know where that was going, and I can't disagree. It's totally irrelevant. Might have been heartwarming and sappy.
All right, sure.
We're back. And we're not. Of course we're not, because we have to go to sidebar. See, I knew that. Thanks, Joy, for jumping on for me there while I was sidetracked. But yeah, I figured, yeah. So we will check back in. I'm going to wait till they come back on live here. But we'll check back in at 4-ish whenever they're done, just for a quick moment. And then we'll get prepped for our 6 o'clock tonight, where we have a couple of amazing guests. Somebody who actually lived at, I don't know if lived is the right word, was seeking treatment, stayed at McLean. And we can talk about what she experienced versus what the state of the evidence is in this case. And we can even talk about the staffing issue, depending on what time of year it was. It may or may not be relevant, but I'll allow it. I won't refuse to allow that testimony. And then we have Michael Del Senor, and we'll talk about the mistrial issue and any other procedural issues that we think are interesting as we get toward. Maybe we'll talk about the verdict form. We'll talk about some of the other issues that will be much more important as we roll into next week. I thought we were going to have Friday pretty clear for either everybody off, or at least the jury off, and the parties working on the jury instructions, working on the verdict form. But the way this thing seems to be kind of dragging, it looks to me like we may get through, and there's only an hour and a half left in the day. We may get through the last couple of defense witnesses. We may not. If we only get through one of them, the next one is tomorrow. Then the rebuttal case, got to take most of the day tomorrow. 3 doctors, come on. And we know that the Commonwealth is going to belabor everything they have to say. Cross will be probably relatively short, but still more contentious, because you've got experts on the Commonwealth side basically poo-pooing the defense case. So the cross-examination's got to be a little more intense by Reddington. Then Friday may be some slop over testimony until the defense rests, or it may be, like I said, all jury instruction verdict conference, and the jury gets to take the day off, which I think would be a very good thing. So either way, we are steaming toward, as expected, Monday for closings. Yeah, I know. That's what I called it, the wish egg. I don't know. And here's another. How about the wish vase? Or is it vase? If you pay enough for it, it's a vase. If you get it cheap, it's a vase. Yeah, it's a mystery. I can see it trending. Okay, I never disbelieve Madeira Beach caregiver, a wish pot. Chinese origin, picked up by an artist in Hawaii, apparently. Yeah, wasn't it Kevin Reddington talking about the egg and watching it on television? he modified it today he said computer, on the computer. He's a funny guy. Was it oval? Was it kind of oval shaped like an egg? And Bito? Hey, I can't disagree with this, especially at this point in a trial. I think the jury gets it. They know what each side is arguing. They've got 90+% of the information in front of them that they're going to need to kick around to make a decision. So yeah, this is the point at which, again, if they could read the room, and they can't, they would be tightening things up. But I think that's sort of a special skill that you have, not necessarily just as an attorney, but as a human. Your senses kind of take in what the reaction is. Like right now, I should know to shut up. Okay, here we go. I'll check with you in a bit.
All rise, please. You're entering. Court is back in session. You may be seated.
Your Honor, for purpose of the record, we'll return back to the file of Commonwealth versus Lindsay, Clancy, all parties are present, including the 18-year-olds.
All right. Well, everyone, thank you for your patience. And I'm going to ask you for some more patience. All right. Due to an unforeseen circumstance, we're going to excuse you until tomorrow morning. All right. This is not something we saw coming, but you're not to speculate about what it is. You're not to hold it against either side. It's just something that we have to deal with. All right. And so I'm going to excuse you till tomorrow morning. I'm going to remind you, as I have every night for the last number of weeks, don't do any research about this case. Don't talk about it. Don't read anything. Don't watch anything about this case or similar cases. And with that, we'll bring you back here. We will deal what we have to deal with, and we'll get right back on track. We are still well within the timeline that I gave you regarding this case. But it's just something we can't control. So I'm going to excuse you till tomorrow with my thanks for your patience. And I'll see you tomorrow morning. All right. Thank you.
All rise, please.
All right. Everybody can be seated. Anything we need to address before tomorrow morning?
No, Your Honor.
All right. So we will be in recess till tomorrow morning at 9 o'clock. Thank you, everyone.
Court, all rise.
Well, that is a fine how do you do. Let me check something here real quick. I was going to make a couple of calls real quick, or at least a couple of texts, and just see if anybody still on the ground there has a clue why we're doing this. I'm guessing it's witness availability, but that's just a total guess. Let's see. Just bear with me for a minute. Let me see if I can find somebody. In the meantime, I can tell you our guests are confirmed for tonight. Again, somebody who spent time in the McLean facility, and then we'll have Michael Del Senor on as we talk about some of the legal issues, especially that whole moment, the mortal moment, I'm calling it, with the inappropriate questioning. Let's see. Karen is not there. Let me see. I'll send this to Bob. All right. So let me take a quick look in case any stray stuff has popped in the few minutes that I've been hearing the court do nothing. Nope. It's just bizarre. I like how you guys guess what's in the sidebar discussions. I'm still amazed that there's apparently a microphone over there for the sidebar that the voice recording person can sit at her station and just do it remotely, which is why if you make any noise in the gallery, like Bob Mata was, okay, I was too. And we got the side eye. We got more than the side eye. We got the big giant bailiff coming over. That's twice in this trial that the bailiff has come to me to mention something, and that's never good. I think the biggest drama in the chat now is it a wish egg? Is it a wish bowl? Is it a wish vessel? What is it exactly? That's one way to, where did that go? I put something there. Hold on a second. Why does the camera go to the ceiling for sidebar? Not necessary. Well, because they don't want you reading lips, or, when we're in the courtroom, you can be kind of like, and they do have the white noise, but it's not that loud. And you can all I can tell, and what I try to report on, is the mechanics of who's doing the talking. Is it animated? Is it low key? Because I've seen a couple of times where Kevin Reddington was not happy, and he was this and this, like pointing to the Commonwealth and then pointing to his client, like they're screwing her over, and whatever it was, he was animated. But they don't want that on camera. And they don't want people, recording it and then doing it very slowly, going back, reading lips. I mean, it's just, it's invasive. And to be honest, I'm not sure it's part of Rule 119. The fact is, Rule 119 allows the court to do whatever in the hell the court wants. Judge Gilday, who's operating in that same courtroom in the wrongful death case brought against Karen Reed et al., different rules. Under 119, I can't even have my phone in there. As press, you can't even have your phone in there to do, live texting. You can't, or live posting. So 119 is very broad. It's up to whatever the court wants. I think, as a default position, having been at Court TV and having been at Law and Crime, that neutral position they go to is a default, because they just don't want to. You want to be prudent. You don't want to cause a problem. It has happened where the camera will catch a juror. It has happened. Not in this case, and not often. But when it does, it's a problem. And it's the kind of thing that will, keep cameras out of the courtroom if it were to happen, often enough to disrupt the process. So I think, just to be safe, it's like, let's just go to the in this case, they go to the seal for the great state and county in Massachusetts. So it's not a bad idea. Yes, Karen. So, well, let's see. He's probably going to answer you before me, because you have 8 kids. Yeah, if he answers you first, let me know. I'm guessing it's a witness issue. Those are usually, especially at this point in the trial, you're running out of folks, and so it's not like, hey, let's slot somebody else in and we can do that. No, you're not able to do that. I mean, you're down to a couple, and that's what I think. I really do think we're down to just a couple of doctors, and that could be, doctors are always trickier, unless they aren't, doing a traditional practice of any kind, so they've got more flexibility. I'm sure he's told the parties. I'm sure everybody's well aware what's happening, but some of these housekeeping things, the court is not that willing to share. They whatever their line is, they've drawn it. Madera Beach caregiver asking, shouldn't the judge say if it's witness transportation issue or anything similar? Yeah, it's just, it's the judge's call as to what is really worthy of disseminating. Don't speculate. They're human beings with brains. Yeah, that's right. The more you tell somebody not to speculate, the more they will speculate. That's exactly what it is. Okay, this weighing in, Brian Enton, no clue. Oh, Brian's there now. Again, like I said, people will be gathering. We're done trying that. We are done trying it. I have a feeling. I sent him a note earlier today. What was it? When they, right out of the box, they had that recess, remember? And so I sent him a note. I said, what'd you do now? And he said, it's about you. They're waiting for you to show up. He's not responded to my latest. Paging Bob Mata. Yeah, and there's also the other person. This might work. My friend from where did I put her card? From my friend from the New York Times. I told her, when I'm not there for the next couple of days, would you mind if I reached out? So I'm going to do it. I'm doing it. I'm not going to call her. That would be a little bit obnoxious. But I can text, I think. This is the woman who is kind of on reporter sabbatical for the Times, but she's writing a book. And this case is part of her research. Okay. Maybe I should call. Of course, you probably won't know. My number will not pop up in her contacts. Okay, well, it's done. But whether we find anything out in time or not, it's a different story. Who else do I know is in there now that has... Well, I know. Let me send a note to Lauren. Just checking everybody that I know is in there. Any idea why the early ending? She's usually pretty good at getting back to me. I was asking if she could come on tonight. She's jammed, and maybe she'll come on tomorrow. Okay, I put out all the feelers I can. Again, I think it's probably not. Kathy Rustin says it was witness scheduling. Well, I already said that. I wasn't even around. So that's what I assumed, since there were only a couple of witnesses left. Okay, so I'm going to give you the rest of the afternoon off. So enjoy that. We'll circle back. See you at 6 o'clock. Again, we'll have a guest on who will testify here, who spent some time at McLean as a treated patient. And then we'll have Michael Delson, you are on. And of course, Linda Kenny Baden will be back in the mix. So please join us then. We appreciate you hanging out for the day. Case is, it seems like we've downshifted. We were moving along pretty good. Now I think we've downshifted to a little slower pace, but we're getting there. And I still think Monday is very doable. And of course, Justice TV will be back there then as we dodge all of the other folks that are parachuting in. All right. Have a great
Riding flames, they charge with mine.